right. Hear ye, hear ye, hear ye. For the appeals of the state of Michigan is now in session. The Honorable Christina Robinson Garrett, the Honorable Philip P. Mariani, and presiding, the Honorable Michael J. Durden. All persons having business herein draw near to attention and they shall be heard. God save the United States, the state of Michigan, and this honorable.
Thank you, Vince. There are a lot of veterans out here today and a lot of perceptive attorneys. They'll notice that this is not Judge Robinson Garrett to my right, but it's Judge Cameron. There's a conflict in the first case, so he's going to be handling that. But we have a very, very full docket today, extremely full docket. And we've just spent the past month reading everyone's filings, their briefs, the replies, the record. There's no need for anybody to get up and start reading their brief. Get to the point. If there are contentious issues, that's what we want. We don't need the background. We don't need the facts. We know that. Okay? Get up, get to the point, and get down. Otherwise, if you're intent on taking 30 minutes, hope you brought your sleeping bag because we'll be here until way into the night. So without further ado, we'll call the first case today. It's number 5 on our docket, People versus Tony Isaac Tilley, case number 372758.
Good morning, judges. My name is Robert Tomac. I represent the appellant Tony Isaac Tilley. We are alleging insufficient evidence to convict for assault with a dangerous weapon. What I want to point out here is that the complainant, the tenant in the house, explicitly stated that Mr. Tilley did not point this gun at him. And I take issue with the element of battery that is necessary here. We have a situation, factually, the fact pattern is that Mr. Tilley is out in the backyard. This complainant is in his house at the back door. And there's no reasonable interpretation or how one might glean from that there was a battery or a opportunity to commit a battery. I mean, given the distance between the two, and so based on that, we're asking that the court find that there was insufficient evidence to convict of a felonious assault. And assuming the judges have no questions, I want to, for the benefit of the family, Your Honors, who is watching this or will be watching this, I want the court to know that Mr. Tilley is an earnest young man, 23 years old when this happened, and he has the full support of his mother and his entire family.
Thank you, Mr. Tomek. I just have one question. I've been mowing grass a long, long time. I never had a pistol with me. Why was he carrying a pistol?
He does have a valid license.
Okay.
He sent me that information. I mean, there are people who carry, it's called.
Yeah.
And that's the circumstance we live with in this society. I sure don't like it, but it's entirely legal if you have a permit. So,
Okay.
Thank you.
Any questions?
Thank you.
Thank you very much. The case is submitted, and we're going to take a short break because we're getting tired already. No, we have to go back in conference on this one. Thank you, Mr. Tomek.
Michigan is now set.
Thank you for indulging us. Judge Mariani and I just wanted to go back and escort Judge Garrett out to the bed. You may be seated. Calling case number 1 on today's docket, case number 369004, People versus Mark Anthony Tersigni.
Good morning,
Morning.
Mitch Foster for Mark Tersini. And Mr. Tersini has a lot of support today, family members in the back, and I welcome them to the court.
As do I.
I won't need it probably, but I wanted to reserve 5 minutes for rebuttal. I don't anticipate taking the full 30 minutes though. I would like to mainly just, refer you to my brief and my reply brief, but I would like to highlight some of the points. Mark was denied due process through the cumulative effect of the judicial and his counsel's errors at trial. He was denied a fair trial. First, the issue of the jurors were not instructed to deliberate anew. This is a
Yeah, that juror was out, what, 10 minutes, 20 minutes?
26 minutes.
Kind of deliberation went on then. Have you?
We don't know. That's the problem, Judge. It could be, as the prosecutor suggests, merely to select.
They had to elect a foreman, I would guess.
Right.
You know, I've observed juries, different times, and I've read a lot of, had a lot of jury cases, and generally that's what happens. I was almost on a jury a couple of months ago. I made it to the 4th round before they disqualified me. So, but it's not like they were deep in deliberations or anything of that nature that they needed to be re-instructed.
Judge Reardon, I respectfully disagree because we just don't know. I mean,
That's true.
That's what
true.
the prosecutor suggests. And unlike what a jury can decide in terms of the facts, in terms of inferences, and judges make inferences all the time, I don't think we can make an inference what the jury was doing. I think we should be completely prohibited from that. The jurors have not complete, they can't discriminate based on race, and there's certain instructions, but overall the process of the deliberations is complete autonomy. I think the only instruction is to conduct like a business-like manner and make sure everyone has their fair, could say their piece, and they're to elect a foreperson, but they don't say what the process is. I've talked to jurors after I've tried cases, and sometimes they say, they just look at one guy that or lady that appears to be somewhat of a leader type person, and they're like, "What about you?" And the person says, "Yeah, anyone object?" No, that's like a 30-second process.
Or they ask who wants to be foreman, and somebody raises their hand, and
And everyone says, "Okay."
I'm sorry, Judge.
I'm sorry.
No, I apologize. Do you think the speculation is sufficient, to establish prejudice in this case? Because we really don't know, like you said.
Or that's the problem, and that's why the rule is in place, Judge Garrett, because this is the word "shall" is in there. They
So-
must be instructed to deliberate anew.
Right, so the failure to instruct, let's say it was error, you think it's prejudicial, despite the fact that we're not really sure what really happened within that 20, as you say, 26 minutes or 20 minutes or so.
Yeah. The transcript is precisely 26 minutes, so I don't know. It's no more than 26 minutes. So, and that's 12% of the total deliberations. So a lot can happen in 10% of an event. So this is 12%, and we don't know during that other time whether people weren't fully deliberating. So it could be more than 12% if you really look, but we just don't know, and it's all speculation. So in terms of ineffective counsel and prejudice, really, I think we'd have to look at the strength of the evidence. And with this case, it wasn't overwhelming evidence. I mean, it seems like that's a default that prosecutors and sometimes this court will just throw in there overwhelming evidence. But how do you measure that? In this case, we had several family members, people that had known Mark for years and seen him with children, and that character evidence was presented. So we don't know the makeup of jurors. I was on a juror once, and I won a case, and Frank Murphy on assault with intent to murder. And a couple of the jurors went to the bar and actually called me after they were done. And I talked to them, and they said it was just like 12 Angry Men. It started out with 10-2 for guilty, and we picked them off one by one and turned the whole jury. So that can happen. in this case, it could have been the same situation, 10-2, 11-1. And that one juror could have been the 1 or the 2. And then, so we could have preconceived notions of all these other jurors. And this other juror is just plugged in the next day and they got their verdict that morning. It's a couple hours. So we just don't know. And as I mentioned in the reply brief, we really don't want to bring in the jurors for an evidentiary hearing to discuss their deliberation because, I mean, technically we could if the court ordered it, a remand, but I just don't think that that would be appropriate. I think we need to err on the side of protecting the privacy of the substance of the deliberations. There is a time for that when there is allegations of juror misconduct, but there was no juror misconduct here. The juror just, they didn't know they were supposed to deliberate anew, and we don't know if they did or they didn't. But I think this court needs to err on the side of caution and make sure that rule is enforced, because that's why it's there, to have a full deliberation, start to finish, with 12 jurors, not 11 or 11 and a half, or whatever you want to make of it. So, but that's one of the errors that goes into the cumulative effect. The other two that I see are they kind of tied together. We have the psychological records, and this was like a 30-year delayed disclosure case. So there could be records going back, 30 years. And the judge, it almost seemed like she didn't want to go through. She actually said that it was too broad, too many years. I took that to say that she didn't want to have herself or her staff go through all the work. But in this technology, you could scan all those, do a OCR, and search the name of Uncle or Steve as this person that we've identified as a very strong candidate to be the real perpetrator or an alternate suspect. And you just don't know.
And that's based on ST's identification of Steve as a sexual assailant. Is that correct?
Well, there was a text message that indicated that there was a inappropriate touching. It didn't get into specifics, but it was enough, I think.
Between this individual and ST.
Yes.
Right.
Yeah.
But not between Steve and the two complainants here. Correct.
Well, I would have to defer to the record. I don't remember the specifics. I just know that
I mean, that
Steve,
seems like a material point.
Yeah. Steve is identified as someone that does inappropriate things with children. And I think that's enough to establish enough to get through the screening mechanism on Stanaway. I also think that ties into the rape shield issue, because Mark had a due process right to present a defense, and that is under the Hackett case. He is permitted to question the complainants about whether Uncle Steve did anything to them, and that would open the door to the jurors to consider an alternate suspect. And there was no expert testimony about, what our memories are and what children remember and what they don't. And so we don't know that whether or not the children at the time could have thought it was, Uncle Steve versus Mark. So we're just left, there's no record on that, but we do have a right to present an alternate suspect, and that would overcome, the due process right would overcome, the rape shield statute, especially if that was presented as it was by trial counsel. So those two issues go hand in hand, 2 and 3, but they're basically the second issue of cumulative effect of Mark being denied a fair trial. And then the judge, to make matters worse, denigrated the defense by saying, you're trying to embarrass the witness. I mean, Mark's attorney is in a difficult spot. He can object at the time and cause attention to it, or he could request a curative instruction, bring attention to it again. So either choice would have been to amplify this problem. rather than let it go like he did. So, but when he let it go, it was left uncorrected, and the jurors left with the sense that, well, he didn't, the judge is, not on his side. The judge is for the prosecutor. Now, we know that very unlikely that that's the case, but the jurors were there, they heard it, and there was nothing done to correct it. And like I said, that would have just amplified it if they did correct it with a curative instruction. And finally, the other act's witness, there was just a cursory statement of a 403 analysis, but it didn't really, there wasn't any detailed 403 analysis as to why it wasn't unfairly prejudicial. So I'll rest on the brief in terms of that analysis. But that goes hand in hand with the unlawful driving away of an automobile. Doesn't necessarily mean that's a theft offense, but based on the scenario and what I argued in the brief, that could easily be considered a theft offense, especially in light of the lengthy prison sentence that the person received. And it wasn't just a joyriding, which could be prosecuted as a misdemeanor.
But the underlying facts of that conviction aren't in the record, is that right?
No.
Okay.
I just have the sentence that.
Yeah, understood.
Right. So, but I would say it's just practice in criminal defense over the years. Most of those cases meet the elements of theft. You have a intention to permanently deprive, unless it is a true joyriding, which is very small percentage of the UDA cases are true joyriding. They basically want to steal the car. So, but with that, unless there's any other questions, I'll rest on my brief.
Nothing further from me.
Okay, thank you.
Serve a short period of time for rebuttal if necessary. Thank you.
Okay, you have a short period of time. Thank you. Mr. Miller?
Good morning, Your Honors. May it please the court, Joshua Miller, Assistant Prosecuting Attorney from the Appellate Division at the Oakland County Prosecutor's Office. On behalf of the people, we are asking the court to affirm the convictions and sentences in this case. I'll just dive right into addressing some of the points raised by counsel. So first, as to the jury issue, we don't have to speculate what the jury was doing in this case because the record tells us what the jury was doing. The jury was dismissed at 4:52 p.m. with the understanding that the only thing that they would be doing before they retired for the night was to select a four-person. That was it. The defense is the one inviting us to speculate that maybe they did something else, but in 26 minutes, when this issue of the juror who was making this fuss about coming back the next day came up, what deliberations could they have done if this person, if they've been dismissed to select a four-person and now this person is raising a fuss about, I can't deliberate because I can't be here tomorrow. The thing we also have to keep in mind as we're evaluating this issue is that when both attorneys were asked whether they were satisfied with how the court had addressed this issue, they said they were. So that issue was waived. And so this is purely an ineffective assistance of counsel issue. And the defense is just simply speculating that there is prejudice here. The prejudice for ineffective assistance of counsel is that there's a reasonable probability of a different outcome. You can't just speculate that there might have been a different outcome.
So counsel, how do you make that showing? If we're assuming this is not like a structural error, then presumably they have to make some sort of showing of prejudice. How exactly do you go about doing that?
Well, in a situation like, especially with this, because it's a procedural issue rather than a substantive issue, I think that you would have to show that there was some sort of.
But how? Like, take me through the nuts and bolts. Like, how do you make that showing in terms of what was happening in the jury room?
Honestly, absent some sort of evidentiary hearing or some sort of information coming from the jurors after the conclusion.
So an evidentiary hearing procedurally is
perhaps, yes. But there would have to be something to even get you to an evidentiary hearing, perhaps information coming from the jurors that, oh yes, we selected the four-person, but then we started deliberating and suddenly everybody's mind was changed when this new person came in. But short of that, I don't see how you meet that threshold. Does that answer your question, Your Honor?
Yes, it does.
Okay.
Thank you.
As to the psychological records and the rape shield issue, I agree with counsel that they are intertwined with one another. But as to the psychological records themselves, this is purely a fishing expedition, as I outlined in my brief. You have a third person relaying what a fourth person told you about a fifth person. And there is no allegation, and to answer a question that Judge Mariani, that you posed to defense counsel during his argument, there is absolutely nothing in the record indicating that Uncle Steve was alleged to have done anything with our two complaining witnesses in this case. So to try to breach the privilege that protects these records based on something that's completely unrelated with a completely different person does not show that it is likely that these records, however long they may be, are going to contain information that is going to be helpful to the defense. As to the rape shield aspect, the rape shield is very specific about what you can question. And it's evidence of the victim's past sexual conduct with the actor or evidence of specific instances of sexual activity showing the source or origin of semen, pregnancy, or disease. That's it. And what the defense is trying to do here is to say that, well, these incidents, which all, by the way, are said to have taken place at defendant's house, in defendant's bedroom, where there is no evidence that Uncle Steve ever came to that house, let alone stayed there, let alone stayed in defendant's bedroom, somehow we get around the rape shield statute to ask about these incidents, these alleged incidents that Uncle Steve is somehow supposed to have perpetrated. But if they're starting to ask about something that Uncle Steve allegedly perpetrated, it necessarily has to be somewhere else, because there is no evidence in the record that he was ever at the house where these assaults were supposed to have taken place. So I think that's why the rape shield statute bars any questioning on this. Now, the defense was able to present Uncle Steve as an alternate perpetrator, despite not being able to question the complainants about this, because he was able to ask the parents about this. So the defense was presented, and he made quite an extensive argument during closing about identifying Uncle Steve as an alternate perpetrator. So they were not denied the right to present a defense on this issue. As to the admonishment issue, where the court instructed counsel to move on during the questioning of one of the complaining witnesses, that was a completely proper admonishment. When you have an attorney who's cross-examining somebody, and I counted at least 3 times where he uses the word emotional, you're cross-examining not just somebody, not just a witness, but a witness who is claiming that they have been sexually assaulted. And you're trying to repeatedly say, well, you're being very emotional. Were you emotional when this was happening to you? Again, I see that you're being very emotional here. I absolutely think it's within the province of the trial court to curtail that and say, no, you can't question that person that way. This is an attempt to embarrass them. And that is a proper finding under the court rules that allow the court to control cross-examination. Last but not least, I will also rest on my brief as to the 403 issue. The UDAA issue, it's very clear. Binding case law from the Supreme Court and this court, the Hendricks case, says UDAA is not a theft offense. It's close, but it's not there. So it was absolutely proper for counsel to concede that point and not cross-examine the witness with that particular conviction, regardless of what the facts were. As to the sentencing issue, I will also rest on my brief on that, unless the court has any specific questions for me on that point or on any of the other issues.
Ethan?
None for me.
Thank you.
Thank you.
Thank you.
Rebuttal?
Yes. I would like to go first to the juror issue. I think counsel said that the juror said, I can't deliberate. There was no record that the juror said he can't deliberate, or he didn't deliberate, or he will not deliberate. It just said that he wouldn't be available the next day, and they couldn't deliberate until Monday, or he couldn't serve as a juror until Monday. But there's nothing in the record that said that he said to the judge, I can't deliberate, or that he said to other jurors, I can't deliberate. So I just want to make sure that that's clear, and that wasn't part of the record. terms of the fishing expedition, I know that that's a word used in the case law. I think it's in the Stanaway case as well as some other cases. Fishing expeditions are not allowed, and we all know that. But we also have in every Stanaway order where there is a in-camera review, there is some portion of the facts that are unknown. That's why they have it. That's why they do the in-camera. If the facts were apparent, there wouldn't be any necessity to have the review because you would have the facts already. So there is some part of the unknown. So you could call every in-camera review a fishing expedition if you really wanted to. And technically that might be true. But there is a distinction here because we've articulated a good faith basis that there is helpful information, something to do with Uncle Steve. And that would be a quick OCR search to find that, as I mentioned before. If it's not there, it's not there. If it is, it is. In terms of the rape shield, there was a discussion of Uncle Steve not even being in the house, no record of that. Well, we don't know that. And of course, the prosecutor, he's assuming that these allegations are true, that something did happen at the house on Cranberry Lake. But that's assuming that you believe what the allegations are. If there's reasonable doubt and there is no truth established to these allegations, then of course it could have been Uncle Steve at a different location, or it could have been Uncle Steve at that location. So we just don't know. So I don't believe that's a proper analysis in terms of denying a due process right to present the defense, a full defense of the other perpetrator. And we know it was important because counsel argued Uncle Steve in his closing argument, and he wanted to question the complainants about that. So they only gave him half of his due process right of the defense, but they didn't allow, the judge did not allow him to question the accusers, which is the critically most important part of the due process right to present a defense, is the Sixth Amendment right to confront and cross-examination of the accusers. And finally, in terms of the judge's, I would say, unfair admonishment, it was clear that the trial lawyer was trying to point out inconsistent behavior. If she's so emotional at the time of the trial, but wasn't emotional back at the time of the alleged incident, that was an inconsistency that he wished to point out to the juror. And maybe he made his point, but his point was completely overshadowed by the judge's admonishment, which also served to deny him a fair trial. So with that, unless there's any further questions, I'll rest on the briefs.
Thank you very much. Your case is submitted.
Thank you, Judge.
Have a good day.
You too.
Calling number 2 on our docket, People versus Andre Albert Woods, case number 365084.
Good morning, Your Honors.
Morning.
Happy Thanksgiving, belatedly. My name is Garrett Burton. I'm from the State Appellate Defender Office. I represent Mr. Woods. So I raised a number of issues in my brief. I want to talk about the missing witness and then move on to that note and then conclude with a quick point about the search warrant. And so starting with the missing witness, the prosecutor did not exercise due diligence in trying to secure that witness's appearance at trial. Now, before trial, the prosecutor was on notice that this witness was going to be difficult. That witness needed to be incarcerated in order to testify at the preliminary examination. And the prosecutor knew that that witness was going to go to Georgia at some time before Mr. Woods' trial.
Where in the record shows that the prosecutor knew that the witness was going to flee the state?
At a motion hearing, or excuse me, a status conference in February, the prosecutor said that the prosecutor was going to have some trouble with an out-of-state witness.
But at that point, had the witness already left the state?
It's not clear. It seems like,
That's kind of what it sounds like. It's, they've discovered that he
Mhm.
has left the state, so.
yeah, that's how I read it, Your Honor, is that they knew a couple of months before trial that he'd left the
That
state.
he had already left.
Yes.
But not, I guess that's what I'm trying to clarify with.
Oh, I don't
Are
know
you-
the exact date when he left the state. No.
Right, but is there anything in the record to indicate that before he left the state, they knew he was going to?
It's not clear to me from the record that we have
Okay.
right now.
Understand.
I can take a look, and if I find something, I can brief it for you, but it's my understanding from both that motion hearing and then the later motion hearing on the unavailability of the witness, there isn't an exact instance when the prosecutor identifies when the witness was going to leave the state.
That's my understanding.
Yeah. And so, the prosecutor in the prosecutor's brief identifies all these things that the prosecutor says the trial prosecutor did to secure the witness's appearance. But I want to zero in on, one key thing, and that's that the prosecutor didn't make sure that the witness got on the plane when they found him in Georgia, right? And given what the prosecutor knew at that point, that he needed to be incarcerated in other settings, that he was uncooperative, that he was in Georgia, there should have been some step either on behalf of the prosecutor or the police officers in Georgia to get him on that plane.
But I thought, if I remember reading correctly, that the prosecutor here didn't feel like they had any control over, the prosecutor there in Georgia or how, and this defendant appeared for his hearing in Georgia, and they give them kind of like the benefit of the doubt, essentially, that because they showed up, that they would get on the plane.
I have two responses to that, Your Honor. The first is that under Dye, the prosecutor's due diligence requirement is non-delegable. So just because the Georgia laws may or may not be the same as here, doesn't mean the prosecutor is absolved of the requirement to do what's required in the state of Michigan to get that witness here. The second is that there were lots of steps short of actually arresting that individual that the prosecutor could have taken to make sure that he got on the plane, right? I recognize that he couldn't have been arrested in Georgia because they give him the benefit of the doubt, like you said. But the prosecutor still could have called his attorney or sent someone from Wayne County to go down there to say, hey, you got to get on the plane.
Didn't he contact the witness's mother and the mother was uncooperative?
Yeah, that happened. You're talking about the prosecutor, Your Honor?
Yes.
Yeah, before trial, it's my understanding that
They had trouble locating him all the way through, even for the preliminary exam.
yes, that's right.
So, and he talked to his mother and the mother was uncooperative,
Correct.
Would he go on a fishing expedition to find out who his attorney is, or did he have one?
Yeah, he had one. He had someone who represented him in the proceedings in Georgia, is my understanding. And so there could have been communications between the Wayne County prosecutor and that attorney to make sure that he got on the plane to come to Detroit. But regardless of whether you think he was unavailable, the two most important statements that he made at the preliminary exam shouldn't have come into evidence. So there are two statements. The first is that the witness relayed what my client's girlfriend is purported to have said. I'm looking for Trey. That is a declarative statement. The witness is saying that she's looking for him. It was made out of court and it was offered for the truth of the matter. In the prosecutor's briefing, the prosecutor says that that is a question. That's not a question. It's a declarative statement. I am looking for Trey.
What about the co-conspirator exception?
Sure. So that is something that's raised for the first time on appeal. Nobody suggested that they were conspiring together at trial. And I want to be clear, that woman.
Well, I mean, the statements in themselves suggest as much, right? Isn't that basically what's happening here? That's what's being communicated.
But there needs to be, Your Honor, independent evidence apart from the statements to admit them. And so what you're talking about is called bootstrapping, right? You're not allowed to bootstrap conspiratorial statements in order to admit them at trial. There needs to be independent evidence separate from the hearsay statements to establish by a preponderance of the evidence that this is a conspiracy. And I want to be clear, this woman was never charged with this. She's still out in the community. It's the Wayne County prosecutor's contention that this woman conspired to commit first-degree murder and she hasn't been arrested or brought in for questioning or anything like that. And second, the independent evidence separate from the hearsay statements is so thin. All they have is that this woman and maybe my client, he's never actually identified in the car. All that we know is that there's a man in a black hoodie in the car. We're driving around with a gun. That's all we know. And that in and of itself is not enough to establish that a conspiracy took place, especially absent some finding by the trial court that this is actually what happened. Because again, it wasn't raised at trial. And we can have an evidentiary hearing. I did raise this as ineffective assistance of counsel. I moved for a Ginther hearing. So if you need more evidence, we can talk about it in the trial court. But that wasn't established on the record before us. And to just back up a little bit, the second statement, Trey shot me last night. That's also a hearsay statement, right? It was being offered for the truth of the matter asserted that Trey, the decedent, did in fact shoot my client's girlfriend. Now, the prosecutor says that that was being offered for the effect on the listener. And again, that's not correct. First off, it's not like my client, who again may or may not have been in that car, truly did learn that for the first time when she said that and then took some action based on what she said in the car. What's more is that the prosecutor is conflating the effect on the listener with motive testimony, hearsay testimony about another individual's motive. And if the prosecutor is correct, then that evidence is always admissible. And that's something that would be a path-breaking ruling by this court. That's not correct. And I want to make it clear that the statement wasn't used for the effect on the listener throughout the duration of trial. In closing argument, and when the judge made the judge's finding of fact, they both talked about that statement as evidence of my client's motive, and they used it for the truth of the matter asserted. So absent those two statements, there's a reasonable likelihood that my client wouldn't have been convicted.
And is that because you view those statements as what is the only proof of motive, or what? Tell me why they're so important here.
Yeah, that it is the only proof of motive that's offered at all. There's no other independent evidence that my client had a reason to shoot this person. And in addition to that,
What's the general nature of the relationships between the three individuals otherwise in the record? I know, setting aside the actual precipitating comments, but just in terms of their relationships.
It's my understanding that there was some information. The decedent's mother talked a little bit about the relationship between this woman and the decedent, and then there was Facebook information and some lean information that was pulled about how they were, my client and the woman were in a relationship. Before I move on, I just want to quickly emphasize, though, that the nature of that relationship in and of itself is not enough to establish a motive. It's just, if my ex-girlfriend's new boyfriend was enough to establish a motive in every case, we'd have a problem. This is what I'm saying. Next, Your Honor, I want to move on to that note. So, as you'll recall, an anonymous individual came into the police precinct in Detroit and handed a note that identified my client's social media and the girlfriend's social media, and it said Black Cadillac, and they handed that to the police officer there. At trial, the officer in charge tried to testify about that happening, but the trial court wouldn't let her, finding that that was being offered for the truth of the matter asserted, but the contents of the note came onto the record anyway. The trial court learned that that note implicated my client and his girlfriend in the crime. That's impermissible. That's what Washington says isn't allowed. That's that implied hearsay that can't come in. The prosecutor says that was for the effect on the listener, that the note was used to show the subsequent investigation of the police. That's not correct.
It was a part of the chain of events in the investigation, correct? And Washington does kind of distinguish case law to that effect. Washington was a slightly different chain of custody issue, right?
Yeah, I disagree about your characterization of Washington, Your Honor. So I think, and I want to direct you specifically to footnote 8 of Washington. So Washington discusses chambers, which is the case that the prosecutor relies upon. It says that an individual police officer can testify about the effect on the listener, and that's not for the truth of the matter. But in footnote 8, what the court says is that testimony is rarely necessary. It's only necessary in instances where there's some accusation that the investigation itself was infirm. And there was no accusation in this case that particular part of the investigation was something that was wrong or not up to par or anything like that. And so I think what the Washington court is saying is that we're going to cabin Chambers mostly to its facts, and that when testimony like this comes onto the record, there is maybe some effect on the listener component, but that's not the sole component. And there's also concerns about hearsay testimony. And again, I want to emphasize that trial counsel did object in the first instance to this note coming onto the record, and the court found that it was being offered for the truth of the matter asserted and struck it. And we should defer to that finding. The last thing I'll say is about the search warrant. And I just want to make one quick point. The most incriminating thing in that search warrant is that the officer swears that my client, through his social media profile, resembles the man in the security footage who was walking away from the shooting. That's not correct. You can look at the security footage and you can see that he doesn't resemble the person in the social media because it's too blurry. It's too far away. He's moving in a way. The officer simply couldn't draw that conclusion. And I think that sort of conclusion is in so many respects a slippery slope. Because if we're going to allow officers to testify conclusory in these warrants that somebody resembles somebody else without some sort of independent verification by somebody who knows my client or by somebody who could identify my client, that he's the individual in the security footage, what we're doing is we're giving officers carte blanche to conduct searches and secure warrants. So with that.
Nothing further.
Nothing further.
All right.
Thank you.
Your
Thank you, Your
rebuttal
Honor.
time.
Yes, Your Honor.
Good morning, Mitch Tibbs on behalf of the people. I'm also going to rely on the brief. I think it responded to all the points that counsel made in argument. I did want to clarify one thing about the February discussion about an out-of-court witness. I don't know that that was actually about McCormick because there's no indication that we knew that he was going to be in Georgia at that time. There was another out-of-state witness. Miss Gibson was from Kentucky, and they also had to secure her appearance. So I think that February discussion was probably most likely about Gibson and not McCormick, though it's not super clear on the record. Like I said, everything else I think was adequately responded to in the brief. So I'll answer any questions that the court has.
One question. Can you respond to counsel's argument about the co-conspirator exception and the need for some independent evidence to support admissibility under that theory?
Yeah, so obviously that's correct. That's what the rule says. That's what our argument is. And it's a preponderance of the evidence based on the context of what happened, right? So McCormick sees Tarlisa Howard, who he knows, in the car with a man dressed in black and a rifle in there. It's in this black Cadillac that we see on the video driving around where they track the man with the rifle, losing the, whatever, the mask and the hoodie. In addition with the connection between all these people, Tarlisa is dating the victim and is also the mother of defendant's children. So it's not just that she made these statements so she is a co-conspirator. It's their phones are pinging in the area where it seems like they're casing the location. They're together in this car. Defendant is posting these pictures of this Cadillac with these same clothes on that are fairly distinctive. They find the hoodie with the emblem. So it's all of this other evidence, irrespective of the statements that's saying she was there. She is most likely the person that's driving the Cadillac to pick him up after the shooting. So there's a ton of other context that shows by a preponderance of the evidence that she was conspiring with him. And, defense says, well, this is the first time we raised this on appeal. It's because it didn't come up in the trial court, right? There was no opportunity to make this argument because there was no objection to the hearsay statements that they allege in the transcript. So there's a reason that it's only being made now because this is only when it's become relevant.
Understood.
Thank you very much.
Thank you.
Rebuttal?
Yeah, Your Honor. So just quickly about, I think this is a small point, but it appears from the hearing on the unavailability of the witness that they did have notice ahead of time that he would be in Georgia, independent of what was said at that February motion hearing. That's because the officer in charge testified that she was searching Georgia databases for his address prior to trial. So it appears to me that they had some indication that
At some point prior to trial.
some point prior to trial, which I think I think that is the most important piece. Is that there was some notice ahead of time. The second and last point I'll make is that driving around with somebody several hours before a crime is not enough to give rise to a preponderance of the evidence that this conspiracy had taken place.
There's a rifle.
Sure, I agree.
So I
But-
mean, we're at a preponderance. I
Mhm.
guess, counsel's point is that
Mhm.
there's a lot outside of these two particular comments that substantiates the notion that there was a conspiracy afoot.
I
So
disagree.
where does the preponderance, I mean, we have an assessment,
Mhm.
we have a preponderance, we're kind of sitting our appellate level, like where's the reversible error?
Yeah, so I disagree with the contention that there's a lot of evidence. But again, I think the key with a conspiracy is the meeting of the minds. And we have no evidence that there's any such meeting of the minds that they were gonna together in concert work to kill this individual.
Outside of her statements. So
Yes, the independent evidence.
Thank you very much.
Yes, Your
Case
Honor.
is submitted.
thanks, counsel.
On case number 3 on our docket, People versus Christopher Tillman, case number 365758. Good to see you again, Mr. Tomic.
Yes, good morning, judges. My name is Robert Tomac. I represent the appellant Christopher Tillman. The prosecutor and I are in agreement that there should be a remand for resentencing as to the OV1 having to do with the
Do you mean OV2?
I say it's OV2.
Yeah. OV2?
uh,
OV1?
I think they're both at issue.
OV1 it's not on the score sheet, but it was scored 25,
Right.
right?
Yes, but I'm just going with your argument.
Pardon me?
Proceed with your argument.
Yeah. So that really points out the unfairness of this. Here we have a young man. He's got learning disabilities, the record somewhere shows. This friend of his is much older. He follows him and his friend commits murder and he's acquitted. He's acquitted. I don't know how that happened, but so now my client went along. He's the one in prison. And of course, the reason for that under our law is that there's this notion that as long as there's the crime is a natural and probable consequence of what my client did, then he's guilty under this natural and probable consequence theory. I have to say that from my reading, this theory we're in the minority here in Michigan. The unfairness of this is that there's no intent. There's no intent and for him that he committed this crime. And we have to follow this natural and probable cause idea. And so maybe this is something for higher courts, but
I was just going to say this may be something for the Supreme Court. We're bound.
yeah. And I mean, I remember one of the things that came out is he's talking with one of the minors, one of the children there, talking with the young man. He doesn't know what's going on. Next thing you know, shots are fired out and they're both running. So yeah, no intention here, but I understand the probable cause of consequence, but that's where the unfairness lies. So I expect that we'll have a remand for the OV, but that's all I have to say.
I don't have any other questions.
Good for me. Thank you.
Thank you. The
Thank
case
you.
is submitted. I think you're up again. Calling number 4 on our docket, case number 369-383, People versus Jerry Christopher Randall Lyons.
Good morning, judges. My name is Robert Tomac. I represent the appellant Jerry Christopher Randall Lyons. I think this was close. And I point to I hope a relevant detail when we define what is sexual contact, and in the statute lists certain parts of the anatomy, the genital area, the groin, the inner thigh, the buttock, or the breast. And DF, the victim, DF, his testimony was he felt a hand over his stomach. You know, there was no.
Didn't he testify he felt defendant's hand come out of my pants, out of where my underwear are, specifically my belt buckle?
Well, yeah, I know that was all in there, but he said felt something going across his stomach.
Well, coming out of my pants is different than coming.
Well, I don't
Coming
know that. I
across.
don't know. Well, your stomach, your stomach, if your belt buckle is across your waist, then, it's, the argument is that there's no explicit testimony that an intimate part was touched. And I know, you hear this testimony and you say, well, probably what happened, you probably know what happened, but it may not have been. It may have been he
The jury question.
wanted to, yeah, okay, it's a jury. Yeah, and I'm saying it's of course, his argument that there just wasn't enough for the jury to come up with that. I mean, especially because no intimate part of the body was touched. I mean, we all know, we hear these CSC cases, and there's all kind of touching and so forth. There's no question about it. But here, my argument is that there just wasn't enough for that jury to decide beyond a reasonable doubt, given this testimony, that there was this touching that amounts to sexual contact. That's our
It
argument.
does say that his genitalia, his penis was positioned differently. He testifies to that, so that
I don't know what that
There's,
means.
says when his hand came out.
Well, then you
his
have
hand-
to assume that the defendant did that he placed it there. I know there's some pretty straightforward examination by Mr. Cooper on that point. But again, there's no statement that he touched any intimate part, no buttocks or whatever the statute says here. So,
Okay, anything further?
thank you.
Thanks, Council.
Thank you very much, Mr. Tomic. I think that's it for you today, isn't it? Are you? Okay, have a good day. Case is submitted. Calling number 6 on our docket, case number 370-826, Life Skills Village versus Farm Bureau Mutual Insurance Company of Michigan. We have half the courtroom coming. Oh, I'm sorry, there's only 2. Go ahead.
May it please the court, Steve Hicks on behalf of the plaintiff appellant, Life Skills Village. This is a jury verdict that was reached on no cause of action in provider PIP case. I'm going to rely on the brief with regard to the errors that we believe were committed during trial. And I'd like to, if I can, just focus on the attorney fee issue for a moment. In particular, I want to focus on the trial court's conclusion in reaching an award of attorney fees that the amounts claimed were so excessive as to have no reasonable foundation. That's the language that's used in MCL 531-48. And I'd like to just discuss how the court reached that conclusion, or how I suspect the court reached that conclusion. First of all, there was testimony, quite a bit of testimony in this case from Mr. Nate Garden, who was one of the principals at Life Skills Village, with regard to how they set their rates. There are a number of different comparisons. He talked about having done surveys of providers and how much they charge in the Detroit area, the locality. He also said that they often use, where there's a Medicare rate, they'll use 250% of that Medicare rate. Those were two different touchstones that he talked about, both of which I think are indicative that their charges aren't so excessive as to have no reasonable foundation. That 250% of Medicare is pretty similar to what we now have in statute since the No Fault Act was amended. We didn't have it in this case. This accident happened before the No Fault Act was amended. And in particular, if you look at the numbers and you look at what Farm Bureau voluntarily paid in this case, you can see that they're paying about 80%, typically roughly 80% of what the rate is, which is a common thing that happens after bills are reviewed. So that additional 20%, is that really enough to reach a conclusion that it's so excessive as to have no reasonable foundation? And just to hammer home that point, there was some compelling testimony in this case from Mr. Garden, where he was cross-examined by counsel about, well, here's what Blue Cross charges. What's that number? And it was like 129 or something for 4 units of occupational therapy. It was the example that they were using. Farm Bureau paid like 329, and then the charge was actually 405. So counsel, I think appropriately in that context, said, so you're basically claiming an additional $75 here. And that was correct on that particular example. Basically sort of minimizing what was there. But I think it underscores the point, and he was obviously doing it for a different purpose, but it underscores the point that these are not charges that are so excessive as to have a reasonable not have a reasonable foundation. How did the trial court get to that conclusion? That I think the trial court, in much the way the trial went, and I've talked about the errors in jury instructions at trial, the trial court, like presumably the jurors as well, fixated on what does Blue Cross pay. We would say that's not a fair comparison, because of course those are contracted rates. They have volume. They don't delay payment in the way that no fault carriers do. But I think the judge was focused on that because that was the primary theme and thesis of the defense's argument. Other than that, the trial court didn't really tell us much as to how it reached the conclusion that they were so excessive as to have no reasonable foundation, other than to say these charges are more than I've seen. I don't know exactly what she meant by that. With regard to the occupational therapy example, again, we're talking about $400 being charged for 4 units of treatment, hardly excessive. And she did make one additional comment, the judge did, in issuing the ruling, and commented on the fact that, well, Farm Bureau's paid over $1 million on this claim. 2 points there. They haven't paid $1 million to Life Skills Village. He was in the hospital for a considerable period of time, and a lot of that treatment is allotted to that. But how much they paid on the case total really doesn't get you anywhere in terms of figuring out whether it's an excessive fee. So that's our argument there with regard to it. And I think the court can find that the trial judge abused her discretion in finding that these were excessive. If the court disagrees on that, the one other point I'd like to make is with regard to the amount that was awarded. And basically the distinction here is pretty clear. The judge, looked at what would be a reasonable charge for defense counsel services and what would be the amount for the associates that assisted him at trial, and basically came up with a number of hours, multiply it by the rate, and reached a number just under $50,000 for the attorney fee award. It wasn't really a walkthrough of the Smith-Purdue factors that could in itself could warrant a remand. But the broader point that I'd like to make here is that this is a complete windfall for Farm Bureau in this case, because they only paid defense counsel roughly $22,000. It's essentially like a $46,000 windfall to them. And the question becomes, what is really the purpose here of the no-fault attorney fee provision? Is it to compensate them for compensate an insurer for having to pay for counsel to defend the case, or is it really to punish? And I think the statute.
Can I ask you a question? Well, I'm sorry.
No.
Tell me.
Please
So
go ahead.
I'm interested in, I mean, there's two subsections here, right? One and two, and we're talking about two, but I guess tell me about one.
Sure.
This is to, ensure, prompt payment, appropriate payment in a timely way.
Yeah.
What's your position on that subsection? Is that
They're differently worded. It's curious,
Yeah,
but
tell me how.
the provision one is a much clearer hammer because it says an attorney is entitled to a reasonable fee for advising and representing a claimant in an action for PIP benefits which are overdue. So if you establish that it's overdue, the jury finds that benefits were overdue, it's, there's not discretion there. I mean, they is entitled to and it uses reasonable fee, uses the word fee for advising. Subsection 2 is different, and it's differently worded. And I think there's probably a reason that the legislature did that. Subsection 2, which is the insurer attorney fee provision, says an insurer may be allowed by a court an award of a reasonable sum against the claimant as an attorney fee for the insurer's attorney in defense against a claim that was in some respect fraudulent. That's not the case here, or so excessive as to have no reasonable foundation. So the points there in the distinction between 1 and 2 is whether it's discretionary or not. And the second one is, I would argue that the court abused its discretion in this case by awarding them a windfall. And there's support for that. In particular, I focused on an unpublished opinion, Estate of Bernard versus Avers. It is an unpublished opinion, so of course it's only persuasive, but it has a thorough analysis of what attorney fee provisions are intended to do, and I think it's clearly applicable here. So
counsel, I guess
yep.
For
Did I
so for subsection 1, I understand your statutory language distinction. Thank you for that. So for subsection 1, it's I guess if there happens to be some sort of fee capped arrangement in place, it is appropriate for a court, in your view, to potentially award in excess of that actual fee. I guess turn the tables, I suppose.
Sure.
Roughly speaking.
Sure. If you had an attorney working hourly in that case, and you actually had a client that was paying hourly for,
or even just, let's just talk about like just a fee cap.
Fee.
There's some sort of cap that's suppressing sort of what the rate would be. And are you saying that it's appropriate to?
I think it's a fair point, but because the language is different, I think you can reach a different result. 3148 sub 1 uses that reasonable fee. It is talking about fee, whereas sub 2 talks about a reasonable sum. It's a little broader, little more ambiguous as to what's being considered. And I would say more favorable to our position that no, there shouldn't be a windfall in these circumstances. One is just a clearer, and the purpose is what you noted earlier, that, you're trying to get insurers to pay in a timely fashion. That's the reason we do it. And that's why it's more direct in its mandate. The other one, the sub 2 provision, is discretionary and puts it in the trial court's hands because of considerations like this. And it uses different language, I would argue, for very basically this sort of situation. So my arguments with regard to attorney fee are basically that it wasn't so excessive as to have no reasonable foundation. The testimony was pretty clear as to how they derived it. It wasn't out of the ballpark, even though the trial court seemed to think it was. And there's certainly no relevance of how much they paid out total. And if the court disagrees with that, I'd ask that you consider the notion that they are getting the windfall, and that's an inappropriate amount, and reduce it accordingly. Unless the court has further questions, that's really all I have.
Nothing further from me.
Thank you. You have rebuttal time if you want.
Thank you.
Good morning, and may it please the court, Mark Sol on behalf of the appellee. I know they didn't address it, but I do want to address the jury instruction just briefly. It is a verbatim quote from a published Court of Appeals decision from this court, the McGill case. What they're trying to do is to add a word where we said it's only a balance bill case. That's not what it said. It said this is a balance bill case, which counsel for the appellant got up in her opening statement and said, quote, the dispute is whether or not they are still owed money, a balance bill case. And there was no dispute anywhere in the trial that my client paid the overwhelming majority of these bills. As was indicated, we paid over $1 million on this claim. There were 31 separate medical providers. This is the only one that filed suit. So turning to why the court found in favor of the defense on 3148 sanctions, there were really 3 reasons. And when you look at that block of testimony where we cross-examined Mr. Gardine about how he came up with his rates, you have to understand that that's one line item on like a 39-page bill. There were multiple instances where Life Skills had the exact same billing practices, and that's clear in the entire record. But we focused on the 3148 motion on that specific soliloquy back and forth because it shows so well what was happening here. It wasn't what Blue Cross is voluntarily offering up. And I will say this court has found that that evidence is relevant. That's the Spectrum versus Farm Bureau case, which we've cited. Mr. Gardine had negotiated that rate with Blue Cross Blue Shield. So this particular CPT code was occupational therapy. Blue Cross and Life Skills agree that this is worth $152.64 per hour. He then goes and sends Farm Bureau a bill for $406.52 per hour for that same occupational therapy. Farm Bureau paid him $329 per hour for those services, and he elected to stand in front of a Wayne County jury and say, I need another $75. And it wasn't just that one line item. It was for every line item on that bill. So that was one reason why we got 3148 sanctions, is those charges were so excessive as to have no reasonable foundation. You got double what you contractually agreed to with Blue Cross. You sued them anyway, and then you stood there telling us that 409 is the reasonable rate. That's excessive, and that's not reasonable. But there was more. It came out at trial that some of these line items on that bill were for services performed by unpaid interns. So they were standing in front of a Wayne County jury and saying that it's reasonable for an unpaid intern to get $400 per hour. That was another reason why the trial court awarded 3148 sanctions. And then the last reason was just overall sloppy billing. We had a 3-day jury trial on this case. And I'm talking about exhibits 2 and 3 from our appendix and exhibit B from the appellant's appendix. Case started out, bill was $44,000. Then we did initial disclosures, $34,000. I did discovery in January of 2021, $86,000. Then they filed a motion for summary disposition. It was $103,000. Then they asked the jury for $98,000. There was nothing coherent about that bill. As far as the attorney fee, we had a trial claiming that an unpaid intern should get $400 per hour for occupational therapy, and that same litigant is telling you that it's not reasonable for a 20-year experienced trial lawyer who's managing partner of his firm to get $375 per hour. She went through all the P group factors. I know she didn't specifically say, I'm doing factor 1, 2, and 3, but every single one of those issues was addressed. My experience, the amount of labor that went in, the amount at issue, the difficulty of case, the expenses, and the relationship with the client. So,
Well, tell me about the relationship with a client, because that seems to dovetail with the argument about, you have, a not uncommon or, arrangement with
yes.
with the client, and perfectly fine. But nonetheless, where in the record makes clear, how the court actually thought about that. It seems clear that she decided it didn't matter.
So it was discussed at both evidentiary hearings, what the actual rate being paid was. And that can clearly be a factor into what the reasonable amount is under subsection 2, as you were discussing earlier. But It was out there. It was discussed. I testified under oath to it at the evidentiary hearing that this particular client, my firm has been in business with since the 1980s. And we handle hundreds and hundreds of cases with them. We are able to do that at a very discounted rate because they give us so much work. And that's the only reason. The statute doesn't say actual attorney fees. It says a reasonable amount for an attorney fee. And that's why courts have always found that the actual amount may be relevant, and it certainly was, but it doesn't necessarily constitute what a reasonable amount is. And that's what she came up with. I think I originally asked her for 75th percentile for a managing partner, and she gave me something like 60th. So is that, and really that's the question before the court is that outside the range of reasonable outcomes that she would conclude that? And I would say that it's not. So with that, I'm happy to answer any other questions the court might have.
Nothing further.
Nothing.
Thank you.
Rebuttal?
Just a few quick points. First, let me deal with the unpaid intern thing because I think that's most glaring. Unpaid interns are used at Life Skills Village. They're always under supervision. So you still have the occupational therapist there. They may not be performing it in that particular instance themselves, but it's still the same process, still the same thing, and you have to have the OT there to have the unpaid intern. So I think that's really a red herring. With regard to sloppy billing, the number grew. They keep treating them. The number grows as the case goes on. There's more treatment. It's not a discrepancy in the number, other than there was some adjustment at the very end to clarify some things in the billing. So if anything, they cleaned it up before trial to get it right. If there was anything glaring in the record with regard to numbers, it's the fact that there were codes billed for certain services which Farm Bureau paid on some occasions and didn't pay on other occasions. And the adjuster basically said flat out, if that's the case, then that was an error. And there were examples of that, and yet there was no award. Let me weigh into the balance billing thing, because that is the theme here, just as it was in the trial court. And the court, you probably already know some of this, or know this, are familiar with this already. But when we use the term balance billing, I mean, we're using it in a certain context, typically in the context of healthcare, where if you treat in network, you're gonna be the carrier like Blue Cross is going to pay a certain amount, and it's considerably lower. And they do that because they provide volume to the provider, and they also pay you, and they pay you quickly, unlike Farm Bureau, where you have to pursue in litigation to get your bills paid. So the balance is a differential that's not paid within network, and the question is whether you pursue the patient to get that balance or not. Typically, you're not entitled to it. And that's why it's impermissible in the healthcare context. If you treat in network, you're not going to get hit with that bill. You treat out of network, you can certainly get hit with that bill. And that's some of the confusion that was brought into this case below. They hammered and hammered and hammered away at Blue Cross, and they are entitled to bring up what Blue Cross would have paid. There's case law on this. A motion to eliminate would not have swept this out because that issue's been addressed by this court. But the way in which they characterized it and the way in which the special jury instruction was used clouded the issue to basically say, here's what's happening here. Blue Cross only gets 150. I mean, counsel basically said it just now. Blue Cross gets 152. We paid more than that, therefore excessive. I think that's a flawed analysis in the no-fault context, because we're really talking about apples and oranges. And that was basically, they've underscored for me the fundamental problem of what happened at trial, even though I didn't address the balance billing issue. Let me address the amount of the fee. Brother counsel's a very good attorney. And I have no doubt that his services are worth, I can't remember what number she used, the 375, I think that is. But fundamentally, what we're talking about here is whether the trial court engaged in what would be a legal error in awarding a windfall under this provision. And that I think is where the court should focus its attention, is whether it's permissible in this instance, not on whether counsel's worthy of the sum that they came up with. The question is really, are we going to compensate? Are we going to punish? And under this statute, what is called for? So that's really all I have unless there's questions.
I'll have a quick one. To the Purdue factors and the findings that are required, is it
Yes.
your view that there's enough on the record there to glean the court's reason? I understand you disagree with the court's reasoning, but is it your view that there's ultimately enough there to stitch together a satisfactory?
I would say no. I mean, she certainly didn't run through the Smith-Purdue factors. Most trial courts have become disciplined in their application of that. They pretty much know that we've got to create a record on these Smith-Purdue factors if we want to have it. This case was tried a little while ago, but those factors were out there, and there's been case law. I think it's probably as old as the trial that hammers the point that you have to go through them. I don't think she did. I think the one factor that you alluded to is an important consideration. You know, how much work you do for a particular client relationship. I think it's a relationship with the client. I think that factors into my argument with regard to the windfall. So I would say no. I would say it'd be a remand on that issue.
Okay.
Thank you.
Case is submitted. Very good. Calling number 7 on our docket this morning, case number 371590, the state of Harold Phillips versus City of Detroit.
Good morning. May it please the court, my name is Linda Fagans, and I'm appearing on behalf of the City of Detroit and the individual employees here. We know that this is a tragedy, a devastating loss of life, but in this particular case, the City of Detroit and its individual employees are not liable. They're not grossly negligent, nor were they the proximate cause of the injuries, this horrible death suffered by the plaintiff. What happened to Mr. Phillips in 2024 was caused by 3 privately owned dogs that got loose, and they were owned by Roy and Trevina Goodman, which you all know, and they already pleaded nolo contendere to the dangerous animal causing death. Their independent criminal conduct alone, and not municipal discretion or gross negligence, caused the death of this plaintiff. To impose liability, not because the city's employees acted recklessly in 2021 or 22, but because with hindsight, they should have euthanized the dogs earlier to prevent this 2024 attack, does not establish their liability. And I'm going to address, first of all, we know that the city is immune because of the fact that this animal care and control is a governmental function. Getting to the heart, going to address the issue of gross negligence, the lack of gross negligence as a matter of law, and that these employees were not the proximate cause of any. First of all, gross negligence is their failure. One of the things that they argue is that earlier in 2021-22, they should have euthanized these pit bull if they had followed the
They had some contact with these dogs or about these dogs previous to the attack, correct?
Would you repeat the question?
There was some contact by the City of Detroit employees with these dogs prior to this attack, correct?
The contact they had was in 2021 when there was a allegation that the dog bit someone. The situation was investigated. They made a decision that after working out something with plaintiffs, again, these two owners, Trevina, the Goodmans, and they made a decision not to euthanize those dogs in 2021. Now, in 2024, what occurred? The owners, the husband was there, the dogs were in the backyard, and they got out the gate.
Now, this is on the corner of Longacre and West Chicago.
Yes, so, okay.
Was the gate facing West Chicago or was it facing
I
Longacre?
really don't know. I don't recall that, Your Honor. But the point is that they were under the control of the owner.
But counsel, I mean, it seems like part of the problem here is just, this is a very early motion. There's been no discovery. So it's tough to know some of these details that seem like they may bear on, which is not to say that, the claim will be successful, but what we have are the pleadings and then, the city's motion for summary disposition and the particular arguments presented there. And there's, at this stage in the case, it seems difficult necessarily to fill in some of these gaps because we just don't have that record.
Your Honor, and my position is that I disagree. When we looked at with the facts that were pled here and what the allegations that were made by the plaintiff, number one, again, the allegation was that they failed to follow standard procedures of euthanizing the dog in 2021 under the Dunbar score.
Well, I think their allegation was that they, as I read the complaint, that there was a reckless disregard for their duties in pursuit of what was ultimately a profit-driven policy.
Okay,
And I understand you strongly dispute that.
Rest.
But yeah, at the stage we're at, what we have are the allegations.
You have the allegations, but these allegations do not make out a legal claim. Failure to comply with protocol or standard procedures does not establish gross negligence. I established the cases in my brief, stating and citing 4 cases in which the failure to follow a procedure established by the city or organization internal procedure does not establish gross negligence. The other thing is their ideal is they say that they failed to what? They failed to investigate. They failed to euthanize again. Gross negligence is not a mistake. Gross negligence doesn't involve poor judgment. It's something reckless and indifferent. In this case, the facts do not establish, even on their face, that their actions were reckless, that they had no concern. They investigated decision. They looked. The affidavit shows that they went there. They made a decision not to follow that standard protocol. That does not lead to the idea that they were reckless. And nor does it create a genuine issue of fact in here. So if you don't follow a guideline, you don't take the recommended suggested form. But if you look at the case in Mayton, Rakowski and the ones Buffington and Green, Buffington and Green are unpublished decisions, failing to follow a policy or best practice does not establish gross negligence or the failure to follow the case. Again, it is a tragic case, but even more important, the fact is you cannot state, and this is like a fishing expedition. We've been not hearing a lot of that, but this is like that. They're hoping to throw something up here to show that the city's failure to decision, the discretion to not euthanize these dogs in 2021 caused the plaintiff's death in 2024 when the plaintiff themselves, the owners who have pled nolo contundere in this situation to a dangerous animal act, failure to watch the dogs and let them get out. So even if it's on the west side or the north.
Can I go back to 2021? There was a misdemeanor ticket issued, correct? They're alleging at July 9th, 2021.
Yeah.
I say the plaintiffs, and there were hearings scheduled, but the dog owners didn't show, going all the way into December 1st, 2022. Was there any follow-up by the city after December 2022, when the owners of the dogs didn't show for the hearings.
Well,
So we're looking at about a 1.5 year period where these dangerous dogs are at issue for the city.
well, eventually eventually, Your Honor, they did plead nolo contendere. So in this particular, in this case, and they did make, and they made a decision.
In this case, they put no.
Yes,
Okay.
but they made a decision not to euthanize the dogs in this case. They didn't, one person, in the case in 2021, they did not, they went to investigate another person and they didn't, they did not find them. But the city had already, the individual officers, employees had already made a decision that they would, that they felt that they took the right action in this particular case. Now, getting to the issue of proximate cause, the law says under Robinson versus Detroit and even on the Ray versus Swagger that you, in a governmental immunity case, dealing with governmental immunity employees, their action must be the direct, immediate, the proximate cause, not a proximate cause. And if they, and Roy versus Swagger, and I talked about that in my reply brief, went to delineate very carefully this idea that in this type of case, you have to show that, and you cannot, they cannot prove that the employees were the proximate cause in this case, in this particular case. The proximate cause was the owner's failure to watch their dogs 3 years later, and this innocent young man coming home.
This happened in 2024, correct?
Right.
All right, so 2 years later after
Oh,
December.
2 or 3.
Okay.
Well, I'm thinking, and so coming home after going shopping to look for a job where he had his life before him, these dogs got out of the yard of the owners, went walking, and they came upon him and viciously tore him apart. Yes, this is an emotional case, but legally we have to look at the law here, the proximate cause. In Ray versus Sawyer, see, the plaintiff was in their briefs trying to make this some type of fact issue case. It is not a fact issue case. If you look at it, just what you have here, this is a case of an issue of law and that the case established that they weren't the proximate cause. In Ray versus Sawyer, it says, however, under the GTLA, we have held that when assessing whether a government employee was the proximate cause, not A, and that's what they try to emphasize. They want you to think it's A and come up with one factors that their action somehow is a cause. When assessing whether a government employee was the proximate cause of the plaintiff's injuries, a court must determine whether the defendant's conduct was the one most immediate, efficient, and direct cause of the injury. No fishing expedition, no evidence they discover is going to change that in this particular case. In this particular case, I cite you cases in terms of discovery where it indicates that even when discovery is still open, I can't even think of the names of my 2 cases in there, and you see it in the reply brief, state that when there is a chance that you cannot prove that they were government, then you cannot prove the proximate cause, or you're not going to create any new facts, that it is okay because parties cannot differ. You cannot differ that the fact, Your Honor, if we look at the facts, that failure to follow a particular protocol to euthanize the dogs does not constitute gross negligence.
How about the proprietary function? Weren't they receiving a grant from the Best Friends Animal Society or something, the FODACC?
Okay.
To not euthanize dogs?
Your Honor, that's what's the allegation that the plaintiffs made in this case. Our position is that if we want to deal with proprietary functions, you must have an intent that your primary purpose is.
They received a grant. I'm curious, do you know how much of a grant?
No, I don't. And Your Honor, I know I don't recall what that grant, the amount of the grant, but the point is we have an affidavit in here which established that they, whatever funds they got, they used it to defray costs. That the revenue, if you looked at my affidavit exhibit 7 and you look at the exhibit 7A and the affidavit from one of the employees, it states that they made no money off of this. They used it to defray cost in here. Again, plaintiff's ideal is to create a lot of questions of facts and ignore the law when the law states that there's no liability in this particular case. Their intent was not, you have to prove the intent was the primary purpose was to make money. And that was not the primary purpose here. Yeah, you have dog lovers. I'm surprised at the number of dog lovers there are, but that doesn't mean that they were running a business for proprietary function. Yes, they might have wanted to protect dogs. Me, myself, I don't see the value because I don't like dogs, and that shouldn't put that in there. But there are some persons, but that doesn't mean they were running a profitable business here, and we can't get caught up on that particular thing. No intent, you can't prove the intent. Number two, the examples that we provided in there in the affidavit and in Exhibit 7 shows that they didn't make any excess revenue that did not go back into running the animal control business, nor did they make a pecuniary profit here, nor was that the intent, and they did so. When you operate so that you can try to make it a self-sustaining business, so you don't have to plunder so much on the, does not mean there's a pecuniary function. And that's what this case shows. It shows no more. No matter how they create this fact, oh, they got a grant for this, they got a grant for that. That does not. People often get grants for the government to help. Why? Most of the time they're doing it to what? Help defray costs, help to carry on the business so they can sustain, not necessarily to make money, and there's no proof that it was in here. So in all, Your Honor, what's most important, this plaintiff cannot prove that the defendant's actions were the proximate cause in this particular case. They cannot overcome that.
Yeah, I was just going to say, kind of to my colleague's point, I think that there's been a lot of detailed factual allegations in this case. And just listening to your argument, I think it's clear that there are a lot of factual allegations on both sides. And you may actually, win and you might be determined not to be the most proximate cause of the fatal injury here. However, I do think that it may be premature in the sense that because of the detailed factual specific allegations to allow discovery. There's been no discovery. And I think that's where we are. But I think ultimately, I don't know how this case shakes out, but I think that discovery may be most appropriate in this case because of the detailed factual allegations on both sides.
And I understand your position, but as I cited in my brief, there have been instances and cases where just because discovery was still open, that the fact that the trial judge determined to grant summary judgment was upheld in the case. I can't even think of the case name right now, but I did cite two. When I come back for rebuttal, I will. Are there any more further questions? But I just want to emphasize to the court that legally, if you look at the law, what they have alleged does not establish proximate cause or gross negligence. And how much fishing they do is not going to show that they were grossly negligent in this case. And you must prove that. As Your Honor, you seem to see critical. Do you have another question
No,
for
I
me?
understand. Thank you, counsel.
Okay.
Thank you.
You have rebuttal time.
Good morning, Your Honors. Adam Wynn on behalf of Shante Phillips, who is with me here today. And my colleague, Mr. Kamenek, is fond of anecdotes, and he's very fond of a particular anecdote that talked to Judge Garrett, who said, sometimes I wish lawyers would get up and ask, do you have any questions for me? And so I think I'll just start it out that way, because I think the court has expressed what I believe to be the case, that there is a lot of factual development to be done here, no matter how forcefully or repeatedly we repeat that defendants were not grossly negligent in the proximate cause. So
None for me. But thank you.
I have one or two. That's all right.
Yep.
Is there anything that you want to respond to in terms of this no look intent rate play has been kind of ambiently about? How does that factor into the case, if at all?
I don't believe that that is currently in the record at all. I don't find it in our pleadings, and I don't see the defendant produced anything about that. I believe defense counsel is
At the
speaking
trial court
fact.
level? Yeah.
Yeah, at the trial court level. And so there was nothing before the trial court about the particular elements of the offense. That argument was not made. That as I understand it, my personal understanding at this point, which again, we are outside of the record, which is functionally non-existent besides what plaintiff has produced in terms of the text messages from defendant Summerfield speaking about the fact there seems to be lost records from the city of Detroit and her having a premonition that something would happen, not back in 2021, not in 2022, which we didn't hear anything from defense counsel about December 2022 when there's a second bite the city fails to investigate. But she has a premonition in December 2023 that something is going to happen. So my understanding is that there was no guilty plea to an intentional offense. Under our complaint, what we are dealing with is we are not dealing with one actor who clearly formed an intent to cause harm. We're dealing with, under our complaint, which governs at this moment, because once again, defendants have added nothing to the record. Under our complaint, we were dealing with multiple grossly negligent actors. And this is not a case where justice needs to be sacrificed to the word "the" at this stage before no discovery occurs.
Yeah, thank you. I have one more question. That's right. I didn't see, there's been an argument about DACC, that it should be dismissed because it's a subdivision or division within the health department. What's your response to that?
My response to that is it appears to be that the argument is that DACC is not a separate legal entity of its own. And so if it's not a separate legal entity of its own, I don't understand how it can be dismissed. It seems to just be a captioning problem at that point.
I mean, do you dispute whether it should be dismissed?
Do I dispute whether I think if the allegation is that the city of Detroit is the real party in interest and that there's an identity between the city of Detroit and DACC that.
Or is this something that we should, yeah, all right.
I don't think there are any merits grounds for dismissal. I think it's just a matter of amending the caption at that point. If defendants are conceding that DACC and city of Detroit are identical or that the city of Detroit is the real party of interest. So I don't see any need to.
Okay. Understood.
I'm not sure how important this question is, but I'm very curious about it. This incident occurred at Longacre in West Chicago. And the victim lived at Artesian. Longacre in West Chicago is east of the Southfield Freeway. Artesian is quite a bit west of the Southfield Freeway. What was he doing getting off the bus there when the bus, I would assume he was traversing west on West Chicago?
I have absolutely no knowledge of that. The allegations of the complaint, which again are uncontested at this point, as defendant has offered no evidence to the contrary, is that he was returning from the mall.
Okay, you don't know what mall or anything like that.
No, I didn't believe that to be a material fact to the case.
But just kind of curious, either he went the wrong way on West Chicago or he got off the bus early and wanted a nice healthy walk home. Or for some other reason, he stopped at that house.
Yeah, without further factual development, I have no way to respond to that.
Okay.
No questions. Thank you.
Thank you very much. Case is submitted. I will take about a 5 to 7 minute break. Oh, I'm sorry. You Miss Fagans, you have rebuttal. Thank you,
You're
Judge.
telling me what your answer is, but I'm sit up here and I'm going to be bold enough to still go forward. Your Honor, in this particular case, and my position is, and you don't want to hear it, in short, discovery cannot turn on a theory of hindsight speculation. The whole question, they keep bringing up action, whether the city ignored evidence of dangerousness, whether the Dunbar scale was properly applied, whether earlier euthanasia might have prevented the death. And we still say that the actions against these individual defendants does not rise to the level of gross negligence. And if you don't have the gross negligence, not the
You already argued that.
I understand it, but I just want to emphasize, and I know that you're curious about all the facts, but we're looking at what they've pled in the legal and the legal emphasis implications of what they're established. And yes, they threw a lot of facts up, and I don't know what my very competent colleagues meant by, I don't know who meant who had the premonition. I don't know. I didn't have any premonition about this. I didn't understand what that meant. Nobody did. Nobody had any premonition about this going to happen in 2024 to this young man coming home off the bus, about to buy new clothes, hoping to get a job the next day. This happened, unfortunately, but is the city of Detroit and its employees are not liable for this. Thank you.
Anything?
Thank you. Nope.
Now the case is submitted and now we'll take a break. All right. Thank you. I know this is before our 11 o'clock case call. We're still on the 10 o'clock case call. But we have a number of cases. So you guys can sit down. Or if you want to stand up and listen to me, that's fine too. But we have a number of cases today and we'll be here forever, but that's okay. We get paid for it. But the point I'm trying to make is, and there are a lot of seasoned advocates here, we've read everything. So don't come in here and rehash your brief and spend 25 minutes rehashing your brief when we've read it. So get to the point, get to the key issues, and we can move on. With that being said, call number 8 on our docket this morning, case number 372-734, Carrie Basse versus East Michigan Physicians Organization.
Good morning. May it please the court, your honors, Tali Wendrow on behalf of plaintiff. It's our appeal of the trial court's grant of summary disposition on statute of limitations grounds. I'm going to focus on the plaintiff's testimony regarding her March 31st, 22 visit with Dr. Ferentz. I'll be very brief. She said Dr. Ferentz told her that the anchor button, we're assuming that, I'm going to assume these facts are as the defendants have laid out as well, that the anchor button was in the wrong place. And it made no sense to Dr. Ferentz why it would be there. That in and of itself, it's our position, does not establish that he told her that it was Dr. Stewart who placed it improperly, as the trial court concluded. That conclusion is also not consistent with the medical records. Again, we look at the medical records from March 31st. They refer to a fixed or a well-placed ACL repair. And it's especially inconsistent when it's viewed, when those facts are viewed in the light most favorable to the plaintiff and in the context of the reasonable person standard that Bowman references, and plaintiff's own personal history of numerous failed knee replacements. She experienced pain consistently after not numerous knee replacements, knee procedures. She experienced pain after each procedure for various reasons. And additionally, her statements about her disillusionment with Dr. Stewart, which defendants reference, also may reflect simply that she thought Dr. Ferentz might have more. The reason why she went to see him that he might have more resources available to him. I don't think it indicates that she was on notice that she had a possible cause of action in March.
So, counsel, to that point, Dr. Ferentz's sent her to physical therapy, right? Or,
He did.
Okay.
He said after that March visit, he sent her for physical therapy, correct?
okay, and that, and, the referral, the physical therapy referral dated March 31st, 22, stated that the reason for the referral was a failed left ACL reconstruction.
Correct.
So when she showed up to physical therapy and they had that in the file, do you believe that that could have provided notice to her? I mean, she's at therapy. She has to know why she's at therapy. She knows that he sent her to therapy.
And she had therapy. It's, first of all, it's obviously typical for a doctor initially to try more conservative means. And she had gone to physical therapy in the past after her her scope. I think the first scope that Dr. Stewart did. So that was something that she was used to, and again, the fact that I'm not even gonna, it's not really clear that she personally read that. I mean, she did sign off. So it is not really clear that she herself knew, even though it's in the records, that the reason he sent her was for a failed ACL. But
So she testified, though, that at her initial physical therapy examination on April 20th, same year, that she reported that Dr. Ferentz had informed her that the ACL reconstruction failed and required a revision,
my
as did her
apologies.
partial knee
Sorry,
replacement.
my apologies.
Yeah.
Yeah.
So that,
So she, but again, as we argued in the briefs, the fact that she knew that that the ACL repair failed was notice to her of of what her injury was, that I have pain, my pain is caused by a failed ACL repair. I don't think it rises to the level that she knew at that point that the failure was due to something he did wrong, as opposed to her own physiology, her own anomalies, as she had what at that point, I think 7 procedures, and was constantly not getting better. You know, from multiple doctors. It wasn't just Dr. Stewart. There was another doctor before that as well. So I don't think that that she learned that causal connection necessarily, that she learned that causal connection in March, as opposed to May, when she went to see Dr. Ferentz and he went through everything, and at that point, knew she had a possible cause of action against Dr. Stewart.
Why wasn't Dr. Ferentz, was Dr. Ferentz deposed?
I don't believe so. And I don't know. Well, the defendants didn't take his deposition. I don't know why they hadn't at that point.
Because it seems like what happened at this visit and in his notes, that that seems to be
And that
an important point.
I agree. And that was something that, if you recall this motion, the defendants filed the motion initially, and the court denied it, saying, well, if we get more information from Dr. Ferentz, that might help, illuminate things. And when they renewed their motion, the only additional evidence they provided were the physical therapy reports that showed that she knew that there was, or arguably knew that there was a failed ACL as of March, that the ACL repair had failed.
It seems like I understand your point about your client's deposition testimony and how it didn't specifically say that it was, the defendant who put the button in the wrong place. But I also don't know if that necessarily is exactly what's needed. And I'm trying to, and then we have this note that from the doctor that seems to be in contrast to that. And I guess I'm wondering why we have not developed this.
Correct. And we don't know, when he indicates in the March 31st, 22 note that it's a well-fixed partial knee replacement. And additionally, that she also testified, I wanted to just find that when she was at page 76 of her deposition, she testified that she had never had a major procedure, this was the first one. Her prior procedures were scopes, and that she relied on the doctors to tell her what to expect and how she was doing. So she'd had this, and that just, again, I'm highlighting her history of these knee procedures, and the fact that she decided to have a second opinion from Dr. Ferentz. and that she learned that there was a failure of the ACL repair. Dr. Ferentz, she testified that he's told her he didn't know. I mean, that was her testimony, was he didn't know why it was in the wrong place.
Didn't she also say in her deposition, I think it's page 119, 120, that she thought that Dr. Stewart didn't know how to help her anymore, and he didn't want to say it.
So, right, and that's where I don't think that testimony means, therefore I knew he messed up.
Well, she knew something was
She
wrong.
knew well, she knew she needed a second opinion. That would be almost like saying, I don't like what they're saying over here at Carmano, so I'm going to go to U of M. And therefore, it's your due diligence to get a second opinion if it's a serious issue. And I think, again, maybe she thought, if I go see this doctor in Metro Detroit, he might have more resource. I mean, she didn't testify to this. I'm saying, it could have been, she
You're
thought he had
saying
more
what you would do.
resources. That's what I would do. No, but that, he might have more resources. Maybe he's more creative. I've heard great things about this guy. Just because he might be,
We can only speculate.
right, but
right.
because he might be a better doctor doesn't mean that Dr. Stewart, that she knew Dr.
Or that-
Stewart, in fact,
We could
Did something
speculate,
wrong.
God, this guy screwed up. I better go to somebody else. Now, go ahead.
yeah, that's, again, I don't believe that the evidence shows, for purposes of summary disposition, that she made the causal, that she knew that there was an injury, that's first part, but that there was a causal link to possible cause of action against Dr. Stewart as of March of 22. Thank you, counsel.
You have rebuttal time.
Good morning. May it please the court, Michael Cook on behalf of the defendant appellee, Dr. Mark Stewart. I think the facts, the pertinent facts, at least from my perspective, are not disputed. And I'll point you to the second summary disposition hearing. Plaintiff's counsel admitted at that March 31st visit with Dr. Ferentz, she was told that the ACL surgery had failed and that the button was in the wrong place. The standard here isn't actual discovery. It's discovered or should have discovered. The plaintiff's argument really gets more at actual discovery. No one actually told me that this was malpractice. But when you're told the surgery has failed, the button's in the wrong place, we're under the possible cause of action standard for should have discovered. They're aware of the injury, they're aware of a possible reason for it, the button's in the wrong place, you should have discovered. And I want to point you to an important line from the Supreme Court's opinion in Bowman, where it says a plaintiff is not entitled to await a definitive professional opinion or subjective belief in the linkage between injury and cause. That's what they're arguing for. This court has also said similar things. She had enough information to have a possible cause of action to explore that. That's what the discovery rule encourages you to do. Judge Mariani, I do want to address your point about Dr. Ferentz being deposed. So from my perspective, we have her testimony, we have his medical records, we have physical therapy records, including her reporting, I knew this failed. They did not depose Dr. Ferentz. We didn't have to depose him. They could have deposed him. We've moved for summary disposition. It's their burden to produce evidence of question of fact. They had 17 months from when this action was filed, 11 months from when she testified that I was told the button was in the wrong place. And I think an additional 4 months after we first raised the issue in summary disposition. So if he wasn't deposed, if that's a material point, to me, that falls on them. I think we've established what his diagnosis, what his communication was, and that she had enough to know of a possible cause of action.
So I guess when you say you've established what his diagnosis was, I guess this is where I get a little stuck. Now, I understand each of you is going to argue the other one should have deposed Dr. Ferentz, and and I understand that, but you're moving for summary disposition. Ultimately, it's your burden to show no genuine issue of material fact, and the fact is the record still contains, from Dr. Ferentz, what we have are his medical records, and what we have is a note from his visit at March 31st that does not reflect, what other evidence in the record seems to suggest. Right, that it seems like his diagnosis, as reflected in that note, doesn't reflect any diagnosis of a misplaced button. Am I understanding that correctly?
No, well, I don't think so.
So tell me about how that note doesn't how it squares up with the rest of the record without just
Sure.
kind of assuming you messed up.
No, yeah, and I'm not saying that he must have, there is in the record his prescription to physical therapy that specifically says failed ACL reconstruction. So that is a note directly from him as to why she's going there. There's also.
How does that reconcile with the visit note?
So in terms of whether it's fixed, I don't think that gets to whether the button's in the wrong place or not, right? And whether it's in place, the way it was put in, doesn't really reflect whether or not the ACL linkage has actually joined up and healed. I think that's a misinterpretation of that line. And when you look at what he actually prescribed, what she was told, her understanding, and that's really what it comes down to, is her understanding was the ACL reconstruction failed, the button's in the wrong place.
She testified to that, didn't she, during
Yes.
her deposition?
Yes.
Okay.
So, and we are really looking at her perspective of what she said she was told.
And that was as
that's
of
where-
March 31st, 2000.
And that's where you get to the should have discovered standard, not the, did somebody tell me, yes, this is malpractice? That's not the standard. So if you have any additional questions for me, I'm happy to answer
I
them.
don't have any. Thank you.
That's helpful. Thank you.
Thank you very much.
Thank you.
One thing I wanted to just point out, so our second argument was that there are, at a minimum, there's questions of fact here. That this is theoretically sufficient to send to a jury to have them decide what did she know on March 31st, or was it sometime after? And I know that the defendants addressed this in their briefs as well, but I think the fact that she also went back to see Dr. Stewart after March 31st suggests that she may not have at that point had a suspicion that the failed ACL repair was because of something he did wrong. I think it raises a question as to what she really, reasonably knew at that point. So.
Okay. Thank you very much. Case is submitted. On case number 9 on our docket, case number 369-825, Jamie Dolph versus Auto Owners Insurance Company.
Good morning, Your Honor. Steve Bank appearing on behalf of the plaintiff appellant Jamie Dolph. This is the appellant's
I'm
appeal.
sorry, what's the name again?
Keith Bank appearing on behalf of, appearing on behalf of the plaintiff appellant Jamie Dolph.
Thank you.
This is the appellant's appeal of a jury verdict of no cause of action. And to keep it as brief as possible, the trial court made 3 errors that kind of converged to create this unfair trial. They were allowed to argue that our client was a fraud, even though the alleged fraud wasn't related to any of the benefits she was claiming at trial. They were allowed to argue that her treating physicians were frauds, even though there was no evidence of fraudulent activity or criminal behavior on their part. And then to compound this, when plaintiff tried to introduce evidence of mitigation in the form of her Social Security application and acceptance, she was not allowed to do so. And this evidence would have cut against the basic theme of defendants that she was a fraud, because it would have showed, no, I'm not looking to, milk the PIP insurer for everything I can, and I am looking to actively mitigate damages. So I think, well, maybe any one of these errors in a vacuum might not amount to justifying a new trial. I think taken together, that threshold has been met and this court should remand for a new trial. So unless this panel has any questions, I rest on my brief for the remainder of my argument.
None for me.
Nothing.
Thank you.
Your rebuttal time, plenty of rebuttal time.
Good afternoon, Judge Reardon, Judge Mariani, Judge Garrett, Caitlin Kramer on behalf of the defendant auto owners. I will likewise keep it brief, since I've heard you say a couple times now, Judge Reardon, that you have many briefs today or many cases today. I think the effort by the plaintiff's argument here is to simply list a bunch of errors to hope that you find something cumulative and want to overturn the jury's verdict. But a jury verdict can only be overturned in such a way if there's some substantial interest or substantial violation of justice here. There's not. Our comments were not that the doctors were frauds, but that they have a pecuniary interest in getting their bills paid. That's a simple fact. The jury, I believe, chose to weigh the testimony and the credibility of 2 doctors in this case. And those are 2 doctors that we called the emergency room doctor and the primary care physician. Both of those testified that Ms. Dolph had an extensive history of back pain, which was the main issue in this case. And then the emergency room doctor testified that she had no injuries in the emergency room. I believe the jury took the experts on our side, took the doctors on plaintiff's side, considered them a wash, and looked at those two doctors as the most credible. They were the ones without skin in the game, and their evidence supports the jury verdict, which was a no cause on the basis of no injury. As for the fraud allegations, plaintiff prevailed on that point. The jury didn't find that she was fraudulent. So I don't think that's an issue.
With respect to replacement services.
With respect to it all, Your Honor.
Wasn't I guess you're relying on the special verdict form, correct?
Yes, Your Honor. So the issue was that she had misrepresented her replacement services. She dropped that claim once she was caught. But the judge did allow a question on the jury verdict form to say, had she submitted anything fraudulent? And the jury found against us in that regard. They said she didn't.
Let me just be more specific.
Yes, absolutely.
The verdict form wasn't just a broad finding of fraud with respect to everything, correct? It was a finding of fraud with respect to replacement services. Am I understanding that right?
I don't believe so. I think it was a simple question of, has the plaintiff committed fraud during the course of her claim?
Well,
But we can double check that. I believe it was a broader question. But that goes to my point, Judge, that they didn't find that she committed fraud. I don't think there's any error requiring reversal then when it was included on the verdict form and the jury rejected that argument on our behalf. But as for the jury verdict of no injury, there was ample evidence. It's a 6-day trial, multiple doctors. But again, I think those two doctors were the most dispositive. As for the statements, credibility was inherently at issue, as we outlined in our brief. It always is in a PIP case between a set of doctors. And I don't think our remarks were any different than plaintiffs, where the trial transcript reflects that plaintiff's trial counsel stated on multiple occasions that our experts testify for big bucks. His words, not mine. I think those are distinctions without a difference. We tend to throw around those arguments at trial usually. Again, none of these are cumulative to require standing in the place of the jury in this case, and we ask that you affirm their decision. Thank you.
Thank you.
Thank you.
Super brief rebuttal. The question on the jury verdict form does specifically ask for whether or not she committed fraudulent conduct with respect to her claim for household services. And what the jury verdict form demonstrates is that the jury was frankly confused. It found that there was no fraudulent activity with the presentation of the claim, but then also found no injury. So it seems to be there's inconsistency with the jury verdict. And I think that goes to.
Was the jury actually presented with a claim for household services at that point? Was anything that was actually at issue, they were going to the jury, properly characterized as household services?
The damages, household service damages did not go to the jury, but defendant was allowed to argue that she had presented a claim for fraudulent household services. So we weren't presenting any evidence of household services, but they were presenting evidence of the fraud. So, and with that, I rest. Thank you.
Thank you.
Thanks, Phil.
One question, sorry. Did you concur on that verdict form? Was that the plaintiff? Did they give the okay to the verdict form?
I believe we objected to the inclusion of the fraud instruction.
Okay.
I believe that was preserved.
All right. Thank you.
Thank you.
Case is submitted. Okay, we're finally on to our 11 o'clock case call. Case number 10 on our docket, 371-673, Arkin, Sakara versus Farm Bureau Insurance Company.
Hello again. May it please the court, Michael Cook on behalf of the defendant appellant Farm Bureau Insurance Company. Keeping with your admonition that you've read the briefs, you understand the issue. It's a threshold issue. I'm not going to try to plot through each of the injuries and our arguments on it. I think my reply brief really tried to cut to the quick with pointing out that two of the elements for a threshold are subjective, and there are reasons to contest the plaintiff's credibility in this case, which leads to an issue of fact. If you have any questions, I'm happy to.
This seems like a damages case. You
What do
know,
you mean?
your only issue is damages.
Well, the trial court certainly ruled that, and we're trying to get that reversed. Because we would like to present to the jury and argue on the issue of threshold, whether there is a important body function involved, his ability to lead his normal life was affected, because we do think it all comes down to his credibility on those issues, and those issues are subject to a jury's discretion.
What's the practical impact if we reverse and remand?
Then those issues would be tried to a jury, as opposed to just going to the jury on damages. If you have no other questions, I'll reserve the remainder of my time.
You have the remainder of your time.
Thank you.
A lot of time.
Good morning, judges. Nazak Gapi for the appellee Arkan Zachariah. Your Honor, I think you hit the nail on the head. This is a damages case. The negligence was pretty much admitted. The defendant was at fault for causing the accident. All of the treating physicians and the defense experts agree that the plaintiff was injured in this accident, and that the plaintiff testified that how this affected his life. He testified that he has memory loss, sleep issues, loss of consortium and intimacy, anger, fear of driving, nightmares. And this was based on his treatment with a psychiatrist, Dr. Safu. He never treated with any physician before this accident. He testified that he can't perform household chores. He couldn't go back to doing the job that he was doing. He needed assistance with shaving, bathing, putting on socks and shoes, applying pain cream. The objective evidence showed that he had tears to his knee and his shoulder.
I think we understand.
Yeah, and I'm just going to end with, so Dr. Ali is the PMR doctor that is the only doctor that examined him who said, yes, he's got injuries, but he gave a very short time period of when he should have been healed from his injuries. And that's the only physician on the defense side that ever examined him. Dr. Garver, who only reviewed the record, simply said, I don't agree with how he was treated for his hand. And that's it. So,
But I guess why is that not enough for fact questions? I mean, we're not saying the posture here is, that we're not, defense not necessarily saying they win, but like there's fact questions. We have, they have their IMEs that are calling into question, not the negligence or even necessarily the fact that some injury happened, but maybe what the extent of the injury is, and then also the nature of impairment. So why is that not enough just to put the matter to the jury?
Sure, because the doctors cannot testify as to serious impairment of important body function. That doesn't come from the physicians. All they can testify to is whether he was injured, what his injuries are, what his treatment should or shouldn't have been, and those kinds of things. The only person that can testify about his serious impairment and how it affected his life is the plaintiff.
Is that a legal limitation? Is there a case law that says that's where the line is? Or, I mean, I can understand why you may say, these doctors maybe lack the degree of knowledge and credibility that one's own person would know of their body. But I guess, why is that not a jury question rather than something that entitles you to summary disposition as a matter of law?
In this situation, you would be right, Your Honor, otherwise, but in this situation, there's no testimony or evidence or documentation to refute what the plaintiff testified to and reported to his physicians. So basically, it's just unrefuted what his effect on the injuries on the effect of on his life to his ability.
Wouldn't it always be unrefuted if a person says, I got a sore shoulder and it hurts me? So it meets the McCormick test. And how can anybody else in the world say that my shoulder doesn't impact it?
Well, that's also a great question. He has objective findings. He has tears.
They have medical experts. You have medical experts. Doesn't it come down to a battle of the experts?
Well, then that would overturn all of the cases that this court has held where summary disposition was appropriate in favor of the defense, where the trial court weighed the evidence and said, there's not enough evidence here to show that the plaintiff met his burden of serious impairment. Because I listed all the cases in the last 5 years that this court has ruled where it found in favor of the defense and said there was not enough evidence of injury or serious impairment, and therefore we're going to rule in favor of the defense. All I'm saying here is the evidence is replete with injury, objective injuries, testimony of objective impairments and an effect on his life. All of that taken together, as the trial court saw, was overwhelming compared to the reports of the defense experts, who basically said, the IME doctor, Dr. Ali, just said, yeah, he's injured. He's got tears. He's got injuries. He doesn't dispute that. He's just saying, well, he should have healed 3 months from the time of the accident happened, which doesn't speak anything to the overwhelming evidence on the plaintiff's side of his injuries and his effect on his life.
Okay,
It's
any questions? Thank you very much. Mr. Cook?
I don't have anything to add. Do you have any questions for me?
We have no questions to add.
Thank you.
All right. Thank you very much. Case is submitted. Have a good day. Calling case number 11 on our docket, 365-957, Harbins Cower versus Citizens Insurance Company of the Midwest.
Well, Your Honors, I'd like to reserve 5 minutes for rebuttal if I can, just in case I lose track of time.
Okay, we got an appellant, a cross appellant, appellee, a cross appellee. So wrap up your whole case and your initial argument, save rebuttal time, okay?
I don't get a chance to respond to what.
Yeah, and your rebuttal.
Okay. Your Honor, I'd like to kind of begin this
And who
discussion.
are you?
Sorry,
What's your name?
I'm sorry. Rick Patterson, appearing on behalf of Citizens as the appellant, cross appellee. I'd like to begin this discussion essentially at the end by addressing the sanction issue first, because one, I think it's the most obvious egregious error, but also because I think it demonstrates kind of what defendants were up against at the trial in this case. As an initial point, I will point out that, before we got to trial in this case, defendants had to file 2 separate appeals where Judge Hathaway was summarily reversed on both of those. The second of which is important for the issue of sanctions. At the close of trial, plaintiff's counsel moved for attorney fees under 531.48. The issue there is basically saying it was unreasonable for Citizens to not pay PIP benefits as they were incurred. The problem with that is, in this case, one of the exceptions for when attorney fees are not proper or it's reversible error to award them is when there's a bona fide factual uncertainty. And in this case, with regards to whether or not the claim involved a motor vehicle, which I'll address later on, was a bona fide factual uncertainty. It wasn't because we say so, it was because this court said so. And the second appeal, the court ruled that there's a factual dispute on whether or not there was the vehicle posed a danger or whether or not there was a need to take evasive measures. That ruling by the Court of Appeals prior to trial established that there was a question of fact. There was a bona fide factual uncertainty regarding whether or not this incident involved a motor vehicle such that benefits would even be awardable or could be awarded. So despite that ruling finding a bona fide factual dispute, the trial judge said, you know what, I'm going to allow them to get sanctions, not for the entire case, but I'm going to limit it to when I made my ruling on whether or not the summary disposition should be granted in January, I think it was 2018. The problem was that very ruling was later reversed by the Court of Appeals, finding there was a question of fact.
Counsel, just clear up some procedure here for me. This is the argument that you're making right now is in your capacity as cross appellee.
Correct.
Right. So my understanding is that cross appellant has raised a challenge saying that in terms of the limitation of the award. I mean, are you effectively arguing for, and obviously you're opposing that, But it sounds like you're also arguing for more relief beyond just opposition of their affirmative request for relief.
They filed their appeal based on the timing of when they could assert sanctions related to, and it was post a ruling by the trial judge. Our position is that in fact, the entire award of sanctions was improper and should be
That
reversed.
sounds like you're asking for more than just rejecting their argument.
I'm saying that the argument of any sanctions should be rejected. I don't know what distinction you're drawing, Your Honor. I apologize. But my position is that no sanctions are proper in this case. Regardless of the timing.
Right, but wiping away all sanctions would require more relief from us than just rejecting their argument.
And I apologize. My understanding was that was the base, that was what the request was, because it was our position in the trial court from the very beginning, when they filed the motion, that sanctions were not proper in this case based on the law of the case doctrine. The law of the case doctrine being established by the Court of Appeals on the interlocutory appeal, finding a question of fact as to the involvement of a motor vehicle. And because that was a finding by the Court of Appeals, the law of the case in this situation found a bona fide factual dispute, which precluded the award of attorney's fees and would make it reversible error to award such fees based on 531.48. So that is my position, because it's not a timing issue. It's the fact that they were awarded at all is improper here.
But yeah, I understand the substantive merits. It's just fitting it into sort of the procedural box that we're in as a cross appellate. But I think I understand your position.
Residency is an issue in this case, or was an issue in this case, correct?
Yes.
All right, where does the plaintiff reside?
Well, they reside in Canton.
All right, and they're lawful permanent residents of the United States?
That is our position, yes.
All right, and I know you're not an immigration lawyer, at least I don't think you're an immigration lawyer.
I'm not.
All right, how can that be if you're a lawful permanent resident here? You're supposed to live here in the United States, aren't you?
And they did. They lived at their son's house in Canton, Michigan.
Okay, I thought they
They have a son that lived in Niagara Falls in Canada as well, that they would visit for extended periods of time. Essentially, they were retired and they would travel between their children's houses. But the distinction here
I
is,
thought they owned a house over in Canada.
no, not at the time of this accident. They lived with they had, and that's why the factors that go into deciding domicile, and just jumping ahead to, since Your Honor asked a question, and they basically, there's an argument you can make for the son in Canada, and there's an argument you can make for the son in Canton, Michigan. To me, the distinction here and where there was an error was, if you look at their intent and their actions, which is the one factor that I don't think weighs in both directions, their intent and their actions indicate they were American, they resided and they were domiciled in Canton, Michigan. They answered discovery responses to that effect, saying that was the only place they've lived for the last 5 years. They obtained a green card in 2009, and subsequently she obtained a Medicare card in 2015 or 16.
I thought they were in Canada when she got the Medicare card.
No, Your Honor.
Okay.
They moved to their son's house in Canton, Michigan after he became a citizen in the US, and he helped them apply for permanent residency in the US. He testified they started living here permanently in 2009. And then they obtained their green cards, they obtained the Medicare cards, they had a bank account, they had a treating doctor, they received mail at their son's house. And the requirement for obtaining Medicare, one of the requirements is that you live in the United States for 5 straight years before you get it. And they obviously obtained it in this case, which was an indication that their intention was that they had been residents and was domiciled here for 5 years in order to qualify for that. So all of while the factors may weigh in both sides of the coin, the intent of the plaintiff and her husband and the actions that they had taken towards becoming domiciled in the United States is what the evidence showed, and what, and that's why we were saying that the determination by the jury that they were residents of Canada was against the great weight of the evidence. Now, the jury seemed to, and the plaintiff and me all focused on citizenship. Well, they were citizens of Canada. They had health benefits under Canadian statutes. None of that changes the fact that they had admitted in their testimony they lived here since 2009. They obtained, records. They have bank accounts. They didn't have a driver's license because they didn't drive. Now he does, but all of their actions geared towards
taking advantage of the benefits of living in the United States and staying here at that time. So that is the domicile portion of it. If your honors have any questions about domicile, I can.
Where are they living now?
In Canton, Michigan.
You're still in Canton?
Yes. And they'll say it's because of this accident that she's disabled and she can't move, so they have no place to go. She can't go anywhere, although she has gone to Canada. She has visited her son in Canada since this accident. So I don't know if I don't believe that really holds any weight.
How about the jury's determination that she resided in Canada?
I'm sorry?
The jury determined that she resided in Canada, correct?
They did. They decided she was domiciled in Canada, but again, we just.
So the jury was wrong, is what you're saying.
Yeah, but we're saying that they failed to consider the evidence that was presented as far as their actions and intentions of becoming or of being domiciled in the United States, because that was what their actions were geared toward 2009 up until the accident in 2016. And there's no indication in any testimony in any document that their intent was to be domiciled in Canada. They wanted to hold on to their benefits in Canada because he retired, while working in Canada. But there's no indication.
When you say they wanted to hold on to their benefits, what benefits?
Their Ontario health insurance, the OHIP is the.
So
acronym.
they were getting benefits
They
on
were
both
double
sides of the
dipping,
border.
yes.
Is that legal, I wonder?
I don't know if that's legal. I've done an immigration, as your honor pointed out earlier. But yeah, they essentially were double dipping benefits on both sides, which is why I don't believe the Canadian aspect of it should carry any weight. Let's look at what they did. And what they did prior to this accident was they were domiciled in the United States at their son's house in Canton. Now, another issue that went to trial about, and which is the Court of Appeals found there was a question of fact on, was the involvement of a motor vehicle. And the issue here is when you have to kind of dig into the testimony, because plaintiff's counsel just said, oh, this is a crazy argument. No reasonable person could make this argument that Citizens is making. They're making this thing, they're making it up. There's no basis for it, anything like that, that she clearly was hit by a car. Well, if you look at the actual testimony, she doesn't know what happened. She testified at trial, she testified at her deposition. Were you struck? I don't know. And that was from plaintiff's counsel's questionnaire. Were you hit? I don't know. What did she fell over? Yes, she fell over. And it's a matter of whether or not she was struck by the car. The driver of the vehicle, Mr. Yerkala, is the only one who witnessed it. And he testified very clearly, very plainly, he never struck her. He was able to stop safely prior to getting to her. But she saw the vehicle and apparently she panicked. And I don't know if she tripped or why she fell or how she fell. That's not really the relevant part here. But plaintiff's counsel was allowed to, at trial, and this gets into some of the other aspects of why a new trial is proper in this case, evidentiary rulings, is the trial court allowed the officer that responded. And to be clear, it's a little different situation. She didn't stay at the location where the accident occurred. She was taken to her son's house in the same neighborhood. The officer responded to the house in the neighborhood. He didn't even go to the scene of the accident. But in his mind, he thought that the driver was at fault because it had been called in as a pedestrian versus vehicle accident. So the assumption was, and the son had told the officer that that's what happened. So he was under the assumption this was the vehicle actually struck the person. He didn't test.
Didn't her shoes come off her feet?
Yes. If she fell down, her shoes can come off her feet. The
Shoes
point,
coming off your feet when you fall down? I thought that was a common occurrence.
they weren't like tied, they weren't like shoelaces, they were slip-ons. That if you tumble, they could fall off. I mean, it's something that they could.
I know it's a common occurrence in car accidents when people are struck by cars, their shoes come off.
Well, again, Your Honor, we also had an expert testify that there was no contact, there was no evidence of any contact with the vehicle. There would have been handprints or some type of evidence on the car if she would have been struck. None of that existed in this case. But with regards to the motor vehicle, involvement of the motor vehicle, it really comes down, we're relying on Detroit Medical Center versus Progressive as kind of the basis for our position here. And in that case, the motorcycle was driving 100 miles an hour, saw headlights coming from an opposite street, panicked, laid the bike down and was injured. And the question was whether or not the vehicle headlights that they saw, whether that vehicle was involved. And the
That's a case out of Macomb County, isn't it?
I believe, I thought it was Detroit, but I don't remember. because it's Detroit Medical Center, so I just assumed it was Detroit. But there, the court, focused on, in order for the motorcycle to be considered involved in the accident, the operation of the motor vehicle must have created an actual need for plaintiff to take evasive action. And the actual need part is the important part here, because it's unknown. There's no evidence indicating that Mrs. Carr had an actual need to take any kind of evasive action and try to get out of the way of this vehicle, because the vehicle stopped. And absent an actual need per the published case law, there's no involvement of a motor vehicle. And because he's testified clearly, and there's no contradictory testimony, that he stopped the vehicle, that there was no actual need for her to do anything, and therefore there's no involvement of a motor vehicle in this case. And again, that the great weight of the evidence, the jury decided the opposite direction on that one. I acknowledge that. But we're saying based on the evidence that was presented, that's an improper finding. Lastly, I mentioned that the court allowed the officer to testify as to his thoughts as to who was at fault here, and submit that to the jury, which obviously is improper. There's case law on it. There's a statute on it that basically says that the officer cannot offer their opinion unless they're a witness to what occurred. That is not the case here. So we were stuck with an officer telling the jury that, according to his opinion, was that our person was at fault and actually struck this individual when he didn't see it, wasn't there, and had no basis.
Was that objected to at trial?
It was objected to. We asked for a limited instruction at trial, and it was refused because it was obviously improperly admitted. The other evidentiary thing at trial that occurred is, and plaintiff's counsel throughout this entire trial, he had targeted citizens and basically said that what citizens did here was unforgivable, unconscionable. They made up a story. They made up the crazy claim about the involvement of a motor vehicle, and basically said that there's no other insurance company other than Citizens would ever make this kind of a claim that this accident didn't involve a motor vehicle. Well, when they called the MEMIC claim representative to testify, we sought to introduce, and it's Exhibit CC in our appendix, a letter from counsel for MEMIC stating that they were withdrawing benefits because, based on the testimony of Mr. Yerkala, the driver of the vehicle, he indicated there was no contact, and therefore, without contact, they're not entitled to benefits and they're going to suspend benefits.
Did they use the term crazy? I thought they used the term made up.
They did use made up.
They didn't use crazy though, right? I didn't see it. There's
on page 115, which is 692 from opening statements.
okay.
They made up this crazy claim that Mrs. Carr was walking across the road and fell down.
All right.
So, and again, that was the theme throughout. And when we had the opportunity to expose that as being false and calling out plaintiff's counsel as essentially misleading the jury throughout by saying that, look, here's another insurance company. They also withdrew or suspended benefits based on the testimony of the driver of the vehicle. And the judge did not allow us to present that to the claim rep. It was not presented to the jury.
It wasn't, I guess, my understanding of, and again, correct me if I'm wrong, my understanding of the record there was that the particular claim rep did not have personal knowledge of that letter, and then its admission wasn't otherwise sought through somebody who did. Is that accurate?
The claim rep indicated she did not have personal knowledge of the letter, but it was part of MEMIC's claim file, which was identified as exhibits at the trial, was claim file materials. It was contained in the claim file. Therefore, we think it should have been admitted. Obviously, if it also, plaintiff's counsel at that point had opened the door as far as the argument that this is a crazy story that no other insurance company is going to make. Yet here's another insurance company saying exactly the same thing, but the jury's not allowed to know that. We're going to keep that from the jury here.
No, I mean, I guess I think there's probably a distinction between, whether this could have been substantively admitted and whether there was a proper path taken to do so at this particular trial. And I guess that's what I'm trying to suss out is, there's only an error, obviously, if it's the latter.
I would say it's properly admitted simply because it was identified as the claim file materials were identified as an exhibit for trial. And this was part of the claim file materials. That's the only way we have it, is because we had a copy of MEMIC's claim file. So because the exhibit list was an the claim file was an exhibit for trial without objection from plaintiff's counsel, and this is part of that file, it was basically an exhibit that they acknowledged could be presented until they found out what it said. And then, of course, they have the problem with it. The judge upholds the exclusion of it. The last thing I want to address is that the court allowed plaintiff to rely on and present to the jury the deposition testimony of Dr. O'Keefe. Dr. O'Keefe was a witness in the third-party action, not the PIP case. The testimony that was read to the jury was from the third-party case, not the PIP case. So in essence, the judge allowed plaintiff's counsel to read portions of a deposition transcript from a case that did not involve counsel for citizens to the jury in this case, without any opportunity for us to cross-examine or question this witness at the time of trial, because we were not, her logic was the attorney defending the third-party case was hired by citizens, therefore citizens was represented at that deposition and it can come in. But that's completely different. It didn't involve counsel that was involved in the PIP case and allowed this to come in without any opportunity for us to dispute or refute any of the testimony that was offered. I've kind of hit the points. If there's any questions along the way, I can fill in blanks if necessary.
Nothing further for me.
Nothing.
Thank you, Your Honor.
You have some rebuttal time.
Thank you, Your Honors.
Good afternoon, may it please the court. My name is Tim Deemer. I'm here on behalf of the Appley MEMIC Insurance Company. Mr. Bendure and I collaborated. We're going to split our time. I'm going to address domicile. No other issues. Going to rest on the briefs and let Mr. Bendure handle the other issues besides domicile. I'll start with maybe the panel's questions to my colleague, Mr. Patterson. Judge Mariana, you noted that no cross appeal was filed on the attorney's fees. Again, we're not taking a position on attorney's fees. We have no fight on that. But I will note that's one procedural defect of many with citizens appeal. They asked for greater relief than merely being a cross appellee. That requires cross appeal, which wasn't done. On the domicile issue, we have three technical defaults. The first, in the trial court, their motion was for J&OV, judgment outstanding the verdict, not great with the evidence challenge. I read the written submission, I read the hearing transcript. Not once did citizens argue great weight of the evidence, which is a completely different standard than judgment outstanding the verdict. Citizens not order all of the trial transcripts as they're required to do. That seems hyper technical and pedantic, but it's really not. When we have a standard review of abuse of discretion, how do we know how Judge Hathaway exercised discretion without the hearing transcript? Because the denial of the post-trial motion was for the reasons stated on the record. Without that record, we don't know what she ruled. And then third, I think this is the most glaring to me, is the brief on appeal following a jury trial referenced deposition transcripts from 2018 that were not part of the record that we're reviewing for great weight of evidence challenge. That was the record from summary disposition ruling. So the deposition testimony from Mrs. Cower, her husband Wahinder, has nothing to do with great weight evidence challenge that's before the court today. Secondly, Mr. Patterson said that Mrs. Cower and her husband admitted that they had lived in Canton since 2009. That is patently false. That's not in the record anywhere. I would just use the year 2016 as an example. That was the year of the collision. The first 5 months of the year, Mrs. Cower and her husband stayed with their son Gurpreet in Niagara Falls, the Canada side, not the New York side. The first 5 months, the last 5 months of this accident, they were with their other son Jagdeep in Canton, Michigan.
They were with their Canton son before 5 months before the accident?
Yep. So from until May of 2016, they were in Niagara Falls with Gurpreet. In May, they came to visit Jagdeep in Canton, Michigan in May, and then the accident happened in October. So it's literally a 50-50 split between those two residences. Third, I'm not an immigration lawyer either, but from the trial transcript, how were Mrs. Cower and her husband Wahinder able to stay enrolled in the Ohio health insurance program? It's because they were Ontario. I'm sorry, that's Ohio?
Yes.
Okay.
That's still a foreign country.
Fair enough. It's very good. Well put. Different foreign country. So because they were Canadian citizens and didn't renounce their citizenship, they were entitled to continue to use the Canadian healthcare system. That's there's nothing improper or illegal or unlawful by it. That's why they were able to keep that. Now I'll hop into the presentation I was intending to make after addressing these questions. I like to think of, well, first off, Mrs. Cower, she had two residences. She resided with Gurpreet and she resided with Jagdeep, but you can only have one domicile. This goes back to 1897, the Beecher case, confirmed by Grange, Michigan Supreme Court decision more recently. People can have multiple residences. They can only have one domicile. When you're born, your domicile is with your parents or guardians, whoever raises you, and that is your domicile until you establish a new one. So a college kid who goes to, I'm not going to use the old word, Michigan State for college, might reside in East Lansing, but their domicile remains with their parents because they're only there for part of the year. Then they come back home, back and forth. So domicile stays with where you're born until you establish a new domicile. And I think that is a legal reason why the jury got this decision absolutely correct.
So they said that she domiciled in Ontario, not necessarily resided in Ontario.
Precisely. Yep. She can reside in multiple places, but only have one domicile. So her and her husband's domicile was in India until they moved to Ontario in 1987. And that remained their domicile. They bought a house and they lived in that house until 2007. Okay. Jagdeep, while his parents were still in Canada, moved to Michigan. He moved to Waterford, I think, and then ultimately Canton. So Jagdeep left Canada in 1997. His parents, Mrs. Cower and Mohinder, stayed there for another 10 years after Jagdeep left. Mohinder retires in 2001. They sell their house 6 years later in 2007, and they become total free agents. I'm jealous. They travel the world. They go on cruises. They get to bounce from family member to family member to family member. But when they sold their house in 2007, they didn't come to Canton. They moved in with Gurpreet, who was in Trenton, Ontario. Gurpreet then buys a house in Niagara Falls, again, Canadian side. Mohinder and Mrs. Cower moved to Niagara Falls with Gurpreet, maintaining their Canada domicile. He then buys a second house. They move with him again. They stay with Gurpreet in Ontario. And then at some point, and this came up in the testimony, it was kind of heartwarming about the culture that they lived in, that children take care of their parents as they age. That was what Jagdeep testified to. Gurpreet didn't testify. He's a medical doctor in Canada, couldn't be here for trial. But they all testified that when Mohinder retired, he and Mrs. Cower wanted to visit with their family, visit their grandkids. And they went from place to place to place without ever establishing a new domicile. Temporary residences with family members, yes, but not a new domicile. A domicile is where you intend to remain permanently, and they never established a new domicile.
So, counsel, what more would they have had to do in the United States to change their domicile? I mean, the answer can't be they just stopped seeing their son in Canada. So they did a fair bit.
Mm-hmm.
So like what more?
I think, let's say, for example, they signed a lease for an apartment somewhere in Michigan, or even maybe less dramatic of a step. Let's say if they truly intended to move in with Jagdeep, they would have brought all of their belongings from Canada with them. They didn't. And that's one of the factors that the court's opinion 2022 said was disputed. Where did they keep their belongings? That was a disputed point. And Mohinder testified very clearly, 50-50. We kept half of our stuff with our son Gurpreet in Canada, half of our stuff with Jagdeep. So let's say, again, hypothetically, they took all 100% of their belongings and moved into Canton. That might weigh in favor of domicile here in Canton. Now, let's say they also maintained their own separate living quarters with Gurpreet in Ontario. They still had a bedroom. They still had belongings there. Let's say they abandoned their bedroom. Let's say they brought all their belongings. They no longer had a place to stay with Gurpreet. Then maybe we're starting to shift more towards domicile in citizens' favor. But neither of those things happened. They kept 50-50 belongings between the two. They kept a separate room in both.
Aside from belongings, did they ever spend more than 6 months out of the year in Ontario?
You know, this is another thing that Jagdeep testified to. Part of their culture, we didn't keep track. He said that multiple times. He was asked that repeatedly. How many months of the year were your parents with you compared to your brother or your other sibling who was a daughter who lived in Canada? He said, we didn't keep track. They were free agents, free to come and go as they pleased, welcome to stay as long as they wanted, or they could leave and go stay somewhere else. So no one really kept track. Other than 2016, they were there in Canada for the first 5 months of the year, and then in Canton for the second 5 months of the year. And then the last point that was disputed from the first opinion was intent, which is the most important factor in domicile. That's the primary concern, is what is their intent. Here, the evidence was unanimous. There really was no factual dispute. Mohinder said, we intended to remain domiciled in Canada. Mrs. Cower, through an interpreter, English is not her first language, also said the same thing. I belong to Canada. Jagdeep, the son, said their intent was to return to maintain their domicile in Canada. It was undisputed. And they had no reason to shade the truth. They knew as long as they established a motor vehicle accident, they were going to get PIP benefits from either citizens or mimic. And plaintiff's counsel said repeatedly to the jury, I don't care domicile. I don't care how you decide this issue. We get the same PIP benefits either way you decide this issue. So there's no reason for them to shade their testimony to say we were domiciled here. They didn't get additional benefits or anything different. There was no benefit to the witnesses, which again supports the jury's credibility finding. Like, why would these people lie? Well, I thought you were perhaps,
Well, there's an immigration benefit because they could have to give up their green card if they don't reside in the United States permanently.
Yeah, the testimony on that, I don't, again, not knowing the legal, but Jagdeep said he helped them get that because he wanted to give them flexibility to go 6 months at a time between each son, is what he had testified to. The other, again, just thinking of domicile as a spectrum. On this one hand, you have 100% all the factors in favor of citizens, domiciled Canton. Over here, you have 100% of the factors domiciled in Ontario. We don't have a situation where it's 100% either way. And that's what this court said in 2022. It's disputed on a couple of facts. So there are, for every piece of evidence citizens has, there's counter evidence that mimic has. For example, they highlight the fact that Mrs. Cower had a primary care doctor in Canton. Well, she had a primary care doctor in Ontario. She had an eye doctor in Ontario. When she battled breast cancer, she was an oncologist in Ontario. She had a bank account in Canton. Well, she also had a bank account in Canada. She had Medicare here in the United States. She also had health insurance in Canada. These factors went all over, back and forth, back and forth, back and forth. They're disputed. But on the primary issue of intent, there was no dispute. And I give Judge Hathaway credit. Twice she ruled in favor of mimic on domicile. The first time based on res judicata, this court reversed. Second time on summary disposition, saying domicile is not disputed. It's in Canada. This court reversed a second time. The third time, Mimic moved for a directed verdict on this issue. She's like, look, I agree with you, Mimic. I think you are entitled to judgment as a matter of law, but I can't do that. The Court of Appeals told me, give this to the jury. I admire the restraint she showed. She gave it to the jury, and the jury got it right. They nailed it. The facts, again, the spectrum, it's not 100% one way or the other, but it's clearly predominant in favor of Canada domicile, particularly on the question of intent. Unless the court has questions, I want to leave some time for Mr. Binder. Thank you.
Thank you.
You're keeping track of your own time, how you split it up, right? Because I'm not going to do it.
May it please the court, Mark Bender on behalf of the plaintiff Cower. I have nothing in addition to say on the issue of domicile, one exception, and that is her passport was from Canada, which I think
doesn't make a difference.
Pardon me?
Canadian passport, I don't think has much of a difference.
It seems
there are a lot of people in the United States who have passports from other countries. A lot of people, Irish citizens. I'm a citizen of Ireland, believe it or not. My parents are from there.
Well,
I could carry an Irish passport. I choose not to.
What it seems to indicate to me is that you are looking to that country as being your sponsor.
Means that she came into Canada, had a Canadian passport, became a citizen. That's it. I guess the next step from your argument is she should become a U.S. citizen. How can we tell her that? She has to be a U.S. citizen to have a U.S. passport.
Okay, but at least it shows that her.
Shows that she's a Canadian citizen.
For continuing.
Nothing more. Go ahead.
Okay. And the other thing, of course, is that was never even mentioned as a reason in their motion for JNOV. But let me turn to the issue of sanctions, which I think is tied up a bit with the question of involvement. As Judge Mariani picked up, in this case, the issue of sanctions was raised for them for the first time in the reply brief. It wasn't one of their issues on appeal as appellant. And they mention it for the first time in a reply brief, which simply is not procedurally the correct time. But more to the point, the testimony of the adjuster, Ms. Hill, and it's a transcript, 2 pages 168 to 181, is absolutely clear. The only reason we denied this was because it was a priority dispute. She had no criticism on the issue of involvement. Why? Because their insured first admitted to the police officer that he struck her, after admitting to her husband that he struck her and apologized for it, and after he apologized to the husband. So you have 3 specific contemporaneous times in which he admits striking her. Now, this immaculate fracture theory, as I refer to it, is refuted by several doctors, all of whom say you don't get a fracture at the hip level and the pelvis and lose your shoe and have a head injury by just falling over. And here is his theory. He said, I'm 5 yards away when I first saw her. First perception, 5 yards away. And I just, at 15 miles an hour, stopped the car within 5 yards. It just fell over. Certainly there was more than ample evidence of that. And the important thing for present purposes on the issue of attorney fee sanctions, first of all, the jury made a specific finding when it awarded interest that these payments were overdue because they were not paid within 30 days of the time of adequate proof of the loss and amount. So we already have that jury finding that they had adequate proof and failed to pay within 30 days. And we said some case law in our brief, once you have that finding, the burden now shifts to the insurance company to come up with a justifiable reason for not paying. And specifically in the issue of priority disputes, we have the Griffin case, Blosma case, VHS case, which is cited, all of which say a priority dispute is not a justifiable reason for delaying payment. And the reason is pretty clear if you think about it. The whole purpose of the No Fault Act is to make sure that you don't have people like Mrs. Cower 9 years down the road not getting the benefits that she's entitled to under the No Fault Act. As between the insurers, one of them is supposed to pay, and if necessary, get reimbursement from the other. But you don't leave the insured or the injured party holding the bag.
Yeah, the No Fault Act provides for reimbursement, doesn't it?
I think it does. Certainly the case law does. But in either event,
I think case law says that the No Fault Act
probably does. But any way you cut it, a priority dispute, which is what there was in this case, is just not a justifiable reason for paying benefits. And if it turns out you owe it, then you're stuck for insurance, but also for the attorney fees, because bear in mind, one of the purposes of the No Fault Act is to avoid the need to hire attorneys.
Doesn't work.
Pardon me?
It doesn't work very well.
No, it doesn't. And I'll tell you what, when you have a priority dispute like this that drags on for 9 or 10 years, you see one of the reasons that a lot of people aren't real fond of insurance companies and have a lot of justifiable criticisms of how in actual action, the No Fault Act doesn't always carry out its purpose. If you want to talk about additional, I mean, We had doctors, we had all kinds of evidence of involvement, even overlooking the 3 different admissions that Mr. Yurkola made on the day of the accident itself. We've gone through in the brief, and I need not go any further, but my point is there's all kinds of evidence of involvement, besides which it doesn't even require contact. If the plaintiff's injuries were sustained in response to an auto, that's involvement. So it really doesn't matter in the overall scheme of things. But the evidence of actual contact is ample. I urge you to look at the transcript and the citations, because a lot of the things that counsel has said about the evidence, you'll find there were no objections, or the judge had a alternative reason for the ruling. For example, he talks about introducing the testimony of Mr. O'Keefe in the first party suit. Mr. O'Keefe's testimony was never presented to the jury. What happened was this: he got the mimic adjuster who had gotten on the case later and tries to ask her about a letter that she had no knowledge of and learned only by conversations with her own counsel. Mimic objects and says it's privileged. It also comes out that she has no knowledge of it. The judge says, I'm not going to admit the letter, which they never even offered. I'm not going to admit the letter, but if you want to get into why you refuse to pay, have at it. And defense counsel at that time said, that's fine, that's good, I'm happy with that ruling, and proceeded to question her about it. Likewise, when they complain about the opinion of the officer, I think you'll find that's another issue that was never objected to. And in fact, defense counsel himself questioned the officer, who was eminently well qualified and had heard the admission of Mr. Yurkola. He certainly, if it had ever been brought up and taken into issue, which it never was, if that had happened, he would have been eminently qualified to offer opinions about what happened, based not only upon his reconstruction and experience, but talking to the people who were involved. And it seems to me entirely appropriate for an attorney who's faced with an insurance company whose own insured 3 times admits contact, has fractures at the basically where a bumper would be, loses a shoe, as cars do, as happens in car accidents, and then comes in to talk about this immaculate fracture after having already admitted it. It seems to me it's a fair inference as an attorney, to which there was no objection, to say, must have made that one up after the fact. I think that's a pretty impelling conclusion to reach. I'll be happy to address any additional comments the board may have or questions, but I think I've handled it all.
Nothing for me.
Just want to clarify, I'm not a citizen of Ireland. I could be a citizen of Ireland if I wanted to. And my parents are US citizens. They acquired it. So I am Irish by
It turns out my wife is a Canadian citizen because her grandfather was there, and in a certain year.
I am eligible to compete for the Irish in the Olympics, so I am. But no, I have nothing further. Go ahead.
Okay, thank you.
All right, Judge, we'll look for you next year in LA for the Olympics, right? On behalf of Ireland.
100-meter dash.
There you go. Briefly, as far as the domicile issue, again, as Council indicated, I indicated previously, most of the factors you can go back and forth and you can say it's 50-50, son here, son there. But the one that matters, and the one that is not, is the intent. all of their points are looking backwards. From 2009, when they moved to Canton, prior to that, they lived in Canada. They were domiciled in Canada. No objection to that. In 2009, they moved to their son's house. They get green cards. They then apply for a Medicare card. They develop, a physician-patient relationship. They have a bank account. All of those things after they move to the United States shows their intent to be domiciled in the United States. All of the other information is past looking. It's things that occurred in the past that have no bearing on what their intent was. All of the things that relate to their intent are forward looking, and those occurred in Canton, Michigan, in the United States, and that's where they were domiciled at the time of this accident. With regards to the council said mentioned it 3 or 4 times that there were some admissions by Mr. Yerkela. There were no admissions by Mr. Yerkela. He never admitted to Mr. Singh. He never admitted to he never said anything to the officer. And the officer testified that the information came from plaintiff. It came from plaintiff's husband, not Mr. Yerkela, as far as that there were contact. That's what he is. The husband didn't see it. He's down the street at a neighbor's talking to a neighbor. And turns around and she's on the ground, runs over and assumes that there was contact, but he never saw it. She can't explain it. The officer didn't see it. It was never admitted. Mr. Yerkela never said it to him.
These are all in the record. We read it.
They brought it up. I'm simply reinforcing it, Your Honor. I apologize. The other thing he's talking about, the phantom fracture, Dr. Hake, who is the surgeon who performed the acetabular fracture surgery, I think her falling to the ground and hitting the ground in that manner could certainly cause this fracture. So it's not that, there's no basis for her to have a fracture from falling down. Their own doctor gave it to us. He said, yeah, that's possible. So the idea that there's no evidence and there's no possibility for any of these things is simply untrue. I would encourage, again, he asked you to look at the transcript. I would agree with that, because they make a lot of surface level claims that when you dig down into what the actual testimony is, what did the officer actually say? He didn't say that Mr. Yerkela admitted to him. He didn't say that he has any personal knowledge of it. So all of those things. And lastly, as far as the sanction issue, this isn't a priority dispute. The person who first touched this, they didn't have Mr. Yerkela's testimony at that time. So at that point in time, there was a priority dispute. But once the testimony of Mr. Yerkela came to exist, obviously that provides the basis for the question of whether or not there's an involvement of a motor vehicle. And that's not a priority dispute. That doesn't permit any type of attorney fee award in this case, because that was a question of fact up to and into the trial itself, which precludes an award of attorney fees in this case. If there's any questions.
No, thank you.
Thank you very much.
Thank you very
Case is submitted. Okay, calling number 12 on our docket. Case number 373-521, Nathan A. Thorpe versus Eastern Michigan Bank. And Mr. Thorpe, I believe, is the appellant, and he's going to appear to answer questions, if any. And I don't see Mr.
I'm familiar with Mr. Thorpe, and I do not see him in the courtroom.
Okay.
Frankly, I was expecting him, given the court's ruling.
Okay, I know he submitted his oral argument, a written oral argument, which was an interesting submission. Okay, go ahead, hey, Mr. Tuma.
Yes, I am.
Go ahead.
Douglas Tube on behalf of Eastern Michigan Bank. I will be very brief. If the court has any questions, I'll be happy to answer those now. Otherwise, I'll just comment on a few items raised in the reply brief to which I did not get to respond, and then I'll just rely on my brief for the remainder of the issues. I think what is first most important in the reply brief is what it does not say. as an appellant, you get to craft your issues. You get to pick your issues that you want to raise on the appeal. He chose his.
Well, he's pro per, he's not an
I
attorney, is
understand. I
he?
understand. That's why I expected in the reply brief, after I said, hey, wait a minute, the main issue in this case was the statute of frauds and the commitment to lend. He didn't raise that issue on appeal. I frankly expected the reply brief to say, well, oh, no, wait a minute, I do want this court to reverse the issue of the lower court ruling with regard to the statute of frauds. But after crafting his issues and us saying he did not raise that issue, his reply brief did not take any exception with our position that we said, wait a minute, you didn't do that, and therefore that issue is abandoned. If the issue was appealed, this is a classic statute of frauds case. He initially says that there was a written commitment to lend in July, which is ironic because the loan application wasn't signed until August. But then goes on to be subject to an order that says you must attach, as the court rules require, any document on which you rely to satisfy the statute of frauds, any contractual commitment to lend. He didn't attach that to the amended complaint or the probably improperly filed second amended complaint. So it would be a classic statute of frauds case if it was appealed because there is no document that would have formed the basis for commitment to lend. Therefore, the dismissal of the contract or lending claim based on the statute of frauds was not appealed and therefore is abandoned. Secondly, the reply brief does not take any exception to our attachment of the application, which was an exhibit to the pleadings. So it is properly referenced. The application does say under the Fair Credit claim, it does say that we're giving consent to review of the credit of the applicant. He doesn't take exception to that. Next, we allege that actually, as he stated in the application, this is to buy a drive-in movie theater that he was going to repurpose as an outdoor event center and concert venue of some point. He argues that the Fair Credit Reporting Act would apply. But what he doesn't say is how it's violated. So he doesn't dispute that the application contained a written consent. He doesn't dispute that it's a commercial property and therefore the Fair Credit Reporting Act doesn't even apply because it's a commercial loan. And he doesn't go on to say how, if it did apply, how it was violated. The other thing that's evident in the exhibits that he attached to his pleadings is he said he didn't want his credit pulled until certain things were paid off. He provides not only that they're paid off, but then he provides the password so that we could go on to his personal accounts and verify that the debts were paid. Then we pulled the credit. The credit turned out to be insufficient. Didn't deny the loan, said you can proceed if you pursue a cosigner for that loan, which he did not really ever respond to say yay, nay, or otherwise. So, and the other thing that is curious about this is that he does not claim, he talks a lot in his reply brief about damages, but they're all damages related to the commitment to lend. He does not in any way make any separate claim for damages based on some alleged hypothetical undiscernible violation of the Fair Credit Reporting Act. So we think that if the Fair Credit Reporting Act does apply, there is a proper dismissal of the claim, but we don't think there's any way that it does apply. He did sign an application that included the consent to pull his credit, and he was engaged in obtaining a commercial loan issued by the Small Business Administration. If there's anything more clear that identifies it's a commercial purpose, it's the fact that he's applying for an SBA loan.
And counsel, just if the FCRA doesn't apply, is that fully dispositive of the issues he raises on appeal? Okay, thank you.
The last thing that I'll mention is he tries to get around that by saying we violated our own protocols. Well, banks have rules. Banks can make exceptions to their own rules. It's only a viable cause of action if it's somehow the underlying conduct, other than being an exception.
Or it could be a contractual issue as well.
If there was a contract, which the court and statute of fraud say, doesn't exist in this situation. But nonetheless, the policy deviation wasn't raised before the lower court at the time of the summary disposition motion. So I think it's waived, but nonetheless, he still has not identified in any discernible fashion in what way did we violate a policy and how does that break the law? Because our own policies are not law. The last issue that I will address is simply the issue of the citations in the brief. And I'm not talking about, law school, F3rd, proper year, proper date, that kind of thing. We have spent a significant amount of time chasing down rabbit holes in this case. I don't know if it was ChatGPT or AI, but the cases.
Well, I think we understand the case. It's too bad for you guys,
Yeah.
but
The cases don't say what he says that
all
they
right.
say. And I can go into detail, but it doesn't sound like that's necessary for the court. Is there any question that the court has for me after argument?
Nothing further from me.
Okay,
For your time.
thank you very much.
Thank
The case is submitted. Calling number 13 on our docket. Case number 371690, Walter Winters versus the City of Detroit.
Good morning, Your Honors. May it please the court, Chandler Ola, appearing on behalf of plaintiff appellant. I am going to keep it short and sweet. I'm not going to belabor the points. A lot of what I would say is in my brief, and so I will rely on that. But this is plaintiff's appeal of an MSD in lieu of an answer under C7, where defendant stated that plaintiff failed to plead in avoidance of governmental immunity. Basically, the trial court held that the proper standard under the situation we have was under the EMSA, the Emergency Medical Services Act, which provides for the need of gross negligence or willful misconduct. I think both counsels are in agreement that under the Bortolsky case, the EMSA is the incorrect analysis due to the fact that no medical treatment was being rendered at the time of the transportation.
Right, there's case law directly on point, Arnolowski.
Yes, sir. And so even with that said, given that the EMSA does not apply, in this case, plaintiff appellant would still need to avoid dismissal under the Governmental Tort Liability Act and the motor vehicle exception, which was pled in our complaint. Much like many others, I rely on Martin and Strozier. I could go on all day about the similarities.
Please don't.
Right, exactly. Yes, sir. I'm going to leave it at that and answer any questions that you have for me.
Having questions?
No, none for you. Thank you.
Thank you.
And I'd like some rebuttal time if I could.
Got plenty of rebuttal time.
Good afternoon. My name is Chelsea Grimaldi and I represent Appellee Defendant City of Detroit. I'd like to emphasize that plaintiff's complaint alleges that a city employee was negligent in unloading him from his ambulance gurney. It did not allege facts to plead claim in avoidance of a governmental immunity. Plaintiff's attempts to avoid summary disposition in the trial court were based entirely on inapplicable no-fault law. And plaintiff is now arguing for the first time on appeal that the ambulance was in operation at the time that plaintiff was allegedly dropped, and thus the motor vehicle exception is applicable. Regardless of whether plaintiff was dropped while being unloaded from the gurney or the ambulance, at the time of unloading, the ambulance was no longer operating as a motor vehicle, and activities directly associated with the driving of the ambulance had ceased.
But you gotta stop it before you can take somebody out, right? Otherwise, we have an
Correct.
even bigger problem, right?
Definitely. In that case, we might have a motor vehicle
That
exception
might be
case.
gross negligence.
Yes, yes. But I guess, so in terms of just, I guess, how do you get around Martin when you're having a shuttle bus? People need to get on and off. That's part of what you do when you operate a shuttle bus. Part of what you do with an ambulance is you load and unload injured people.
So I would differentiate between the shuttle bus and the ambulance in that with the shuttle bus, the stop is temporarily intermittent. The vehicle's still in drive. The bus driver is still in the driver's seat while unloading and loading passengers.
Is any of that I guess, is there anything kind of in the decision in Martin that kind of supports that sort of distinction?
So I imagine, yes, because I know that the case that I referred to in my brief, which is unpublished, but the facts are a little more analogous here, points to the fact that this is Tipton, that in that case, the truck was not in a state of being at work. It was dormant in a state of rest, and the motor was off. So here with the ambulance, at the time of the alleged negligence, which was the unloading of plaintiff, the ambulance was in a state of rest, the gear selector was in park, and the EMT who was unloading plaintiff was no longer in the driver's seat of the ambulance.
Could the EMT still, doesn't he have to get out of the car to unload him? I mean, he can't do both, right? At the same time, unless there's
Correct.
like somebody else in there.
Correct. It
And
would
I
be
don't-
impossible for this
Right.
man who was allegedly negligent to have been operating or doing any activities associated with driving the ambulance at the time that he's physically unloading plaintiff outside of the ambulance.
And you're saying that because he got out of the vehicle and was unloading a gentleman out of the ambulance, that he was no longer operating the vehicle.
Correct. And the motor vehicle exception requires for operation to be found that the motor vehicle is being operated as a motor vehicle and it only encompasses activities that are directly associated with the driving of a motor vehicle.
Martin, there were passengers going on and off the bus, correct?
Yes,
All right, while the driver was behind the wheel.
correct.
And I guess if you take, I suppose if we're in the shuttle bus scenario, and I know that this wasn't what necessarily was presented in Martin, but if you're in the shuttle bus scenario and you have a passenger, you know, who needs assistance to get off the shuttle bus, can't do it under their own power for one reason or another. The driver provides assistance. Are we now outside of the motor vehicle exception, helping that person get off the shuttle?
I would say yes, at that point, the bus driver is no longer operating the bus or engaged in activities directly related to driving the bus.
So that plaintiff their claim would be barred by immunity.
It would not fall under the motor vehicle exception.
Would it have to be a bus driver that's certified as both an EMT and also have a driver's license in order to get out of the motor vehicle exception?
I'm sorry, could you repeat the
All right,
question?
let's say that EMT drivers, sometimes people call EMS a bus service, you know, for people that can't afford to get to an emergency room, those kind of things. If let's say the shuttle bus driver, he has a driver's license, he's not registered, he's not licensed as an EMT. Okay, would it make a difference if that shuttle bus driver was licensed as an EMT? Stopping the bus and going to help the passenger off?
No, I would say that given the definition and interpretation of operation as used in the motor vehicle exception, once the bus driver, regardless of licensure, had exited the driver's seat and was helping this hypothetical person off the bus, the motor vehicle exception is no longer applicable because the bus is not being operated as a motor vehicle and the activities are not directly associated with driving any longer.
I think I understand your position.
Okay, thank you very
No
much.
further questions. Thank
Mr.
you.
Ola? Yeah, it's a couple points.
First, in respect to our pleadings, as far as the gurney goes, in our complaint, we put during the unloading process, employees negligently failed to keep the gurney upright. So it was as there was an unloading from the ambulance. It wasn't just the gurney, it was the entire process of taking plaintiff out of the ambulance.
So just to be clear, the fact that you're pleading here is the individual's on a gurney,
Strapped
in the
in.
ambulance, strapped to the gurney. While that gurney was being offloaded from the ambulance, it tipped over, it fell.
Correct.
And you're alleging negligence in that transaction.
Absolutely.
Okay.
The second point, as far as our preserving the issue for appellate review, one of the first throughout our response to the MSD, as well as our motion for reconsideration, we many a times mentioned MCL 691-1405, which is the GTLA. We stated there's no dispute that in order for plaintiff's claims to survive, the same must involve allegations of negligence of a government employee operating a motor vehicle as the same is accepted from governmental immunity. And with regard to Martin, the only differences that I could see in Martin and Strozer, both you had mentioned that the driver's behind the wheel. To me, it wouldn't make sense for, let's just call it if it was a handy capable a van. If the person is in the back of the van being unloaded from the van, they're I think I'm getting sidetracked. I'm gonna come back. In those cases, there are drivers behind the wheel. Sister Council had mentioned that there is a driver for Martin intermittent stops. You know, he's still behind the wheel, still in drive. No discovery was done in this case. In our case at hand, no discovery was done. It was an MSD in lieu of an answer. It got granted immediately. There's a lot of things we don't know as far as whether or not how many people were in this ambulance, how many employees of the ambulance were in the ambulance at the time. We don't know if someone was behind the wheel and going off onto another job. So it would have been an intermittent stop. But regardless, I digress. I'm open for any questions you have.
Sure.
No.
Nothing more from me.
Thank you very much. The case is
Thank you.
submitted.
Thank you.
Any relation to Robert Ola?
No, sir. Not that I'm aware.
I went to high school with Robert Ola.
We're all down outside.
Oh, okay. Calling number 14 on our docket. Case number 372-729, estate of Abdel M. Bazi versus Citizens Insurance Company of America.
Good afternoon, Your Honors. I'm sure you're glad to be reaching the end of the case call here. I guess I count as a seasoned practitioner, so I will be as brief as I can. Excuse me,
Happy to
as
see
I
you,
can.
Ms. Goldman, that's for sure.
Well, I take that as a compliment. Let's think of this as a flow chart. There are 3 nodes. First node, is this argument or is this arbitrable? If the court says yes. Next question, is there an agreement to arbitrate between the parties? If the court says yes, that's the end of what the court does. The case law and the statute say arbitrators decide everything else, including if there are any defenses to the underlying claim.
Counsel, how do you define arbitrable? Tell me what's in your first node.
Well, the parties agreed to arbitrate this dispute over whether Mr. Bazzi's estate by this point is entitled to the PIP benefits that they sued for.
That's separate from, let me know if I'm wrong. That sounded like, is there an agreement to arbitrate?
Well,
or how is it different? Tell me.
Well, the underlying dispute is a contract dispute about PIP benefits. That's an arbitrable claim. And the parties agreed to arbitrate it. So they overlap, but yes, they are distinct issues.
I understand.
And I mean, there are cases in which the court says, no, that's not an arbitrable dispute, although that's relatively uncommon. More often the dispute is, was there an agreement to arbitrate? In this case, there's no dispute about either of those. And, I went through in the brief, I went through the gateway versus procedural issue. The gateway is what we were just talking about. Everything else is procedural. There's law saying if there's any doubt about it, resolve it in favor of it being a procedural issue, leave it to the arbitrators. And the court here just jumped the step, but said, all right, I think that this the statute of limitations is run, so we're not going to send this to arbitration, but the court wasn't supposed to do that. The court was just supposed to say, okay, there's an agreement to arbitrate, leave it to the arbitrators, And at that point, citizens can bring up its defenses. I think we can counter them, but that's for the arbitrators. It was not for the court to decide. Or we can turn the kaleidoscope and say, all right, contract dispute, breach of contract. When did the breach happen? Well, the breach happened when citizens' attorney said, statute ran, forget it. So you could look at it that way too. I think that summarizes what I was going to say.
One more, I guess,
I
definition.
have no questions.
I have one another definitional question for you. I see the term enforceability, enforceable in statutes, case law. I mean, how does the defense of statute of limitations, in your view, interact with the term? Is there an enforceable agreement to arbitrate? Are the terms enforceable?
Well,
Help me understand that.
The court's role is not to decide if the agreement is, if the contract is enforceable. The court is only to decide, is there an agreement to arbitrate? After that, the arbitrators decide whether there's a defense to the underlying claim, which is what this is all about.
I think there's some confusion. There's, at least, for instance, if you look at like the UAA, and I know there's, speed out this, but there seems to be some potentially inherent tension in its provisions about how it's treating the idea of an enforceable agreement to arbitrate being a question for the arbitrator or for the court. And that's just something, I'm trying to get my head around.
Well, there was an agreement. There's no dispute. There was an agreement to arbitrate. And what citizens are saying is, well, that was a contract, therefore the contract limitations or contract statute of limitations applies, and it's been more than 6 years. But if you look at it as the question is the underlying contract or the underlying claim what is being arbitrated, then that's for the arbitrators to decide whether the contract action is barred by the statute of limitations. And there was even one case I found that was directly on point, I think, which I cited, that was Amtower. And there have been quite a few other cases which are comparable. So anything else?
Nothing from me.
Nope. Thank you.
Thank you. You have rebuttal time.
Good afternoon, Your Honors. May it please the court. I am Grant Jaskulski on behalf of citizens. I just want to seize on something that my opposing counsel said, and it's the underlying claim. Whether there are any defenses to the underlying claim should be decided by the arbitrators. I agree, but the underlying claim here is a no-fault claim. And we're not raising a statute of limitations defense to that no-fault claim. The statute of limitations here is on the actual contract, the arbitration agreement, where the parties agreed to go to arbitration in 2009, said, let's do some reasonable discovery. By plaintiff's own admission, that was all done in 2015. By that point, time to go to arbitration. Arguably before, but that's what the record says. Nothing happens. But that's when the right to enforce that arbitration agreement, which is a contract, that's when that right accrued. And then the 6-year statute of limitations runs from that point at the absolute latest, 2015.
So you're saying we don't even have an arbitration agreement anymore?
We don't have an enforceable arbitration agreement. And the enforceability of the arbitration agreement itself is for the trial court. The enforceability of what the claims are, if there was a statute of limitations defense to the underlying claim, if we had a notice issue under 3145 or all the other things of the No Fault Act, if that would be subject to something the arbitrator should decide. Is the underlying claim timed? But this is not the underlying claim. It's the overarching claim of saying, we agreed to arbitrate. We have this contract. I'm trying to enforce this contract. That was the complaint was in this case was we agreed to arbitrate this case in 2009. You've breached that agreement, and I want an order compelling your specific performance of that agreement. But if there was any breach, it occurred in 2015 when it was time to arbitrate and we didn't arbitrate. It didn't occur in 2022 when there's an additional request to an arbitrate a now stale claim and you inform the opposing counsel that, well, that claim is now barred by the statute of limitations. I'm sorry. That doesn't reset the clock. That would defeat the entire purpose of a statute of limitations. You could just use up your do nothing for 6 years and say, hey, I have that breach of contract claim from 10 years ago. And you go, well, it's barred by the statute of limitations. You wouldn't be able to then say, well, now that 6 years is running from now.
So who decides whether or not we have an enforceable arbitration agreement in front of us?
The trial court. And the trial court here looked at.
We don't look at the terms of the arbitration agreement, or the trial court doesn't look at the terms of the arbitration agreement?
You can look at the terms of the arbitration agreement, but if that said, the terms, this arbitration agreement, the gateway question should be decided by the arbitrators, there would be the exception, those things of saying whether we have an enforceable agreement. But here, the arbitrators were only meant to decide the nature and extent of the injuries, whether it arose out of an accident, overall entitlement to benefits and damages. There was nothing about, do we have an enforceable arbitration agreement? And that's the first question that the court has to decide.
Counsel, when the, just indulge me here, when the UAA says an arbitrator shall decide whether a condition precedent to arbitrability has been fulfilled, and whether a contract containing a valid agreement to arbitrate is enforceable, why does this a statute of limitations pertaining to that arbitration agreement not fall within that? Why is that not a condition precedent, for instance, to arbitrability?
There's no condition. It's not saying you have to go to arbitration by this time. That would be like a condition precedent in the contract. But the contract itself, whether it actually can be enforced, is up to the trial court. It's not up to an arbitrator. It would defeat the entire purpose of entering into an agreement to timely arbitrate. And then you wait 10 years or so and you just say, well, now we have to go back to go to arbitration to see if I blew the statute of limitations on enforcing this arbitration agreement. That's the first step. You have to bring it in the trial court, and the court has to say, do we have a valid enforceable arbitration agreement here? Yes, we do. All right, now it goes to arbitration. But if we don't, sorry, you don't have an arbitration agreement here. And here, because the statute of limitations ran, there is no enforceable arbitration.
Got it. So in your mind, this goes to the enforceability, statute of limitations of the
overall agreement, because
agreement
that's the first, that's a first question of saying, is there it's not just, is there an arbitration agreement? Is there an enforceable arbitration agreement? Is there something that's actually binding on the parties here? And in this case, because the statute of limitations is run, there's nothing binding on the parties. And with that, unless the panel has any other questions, I know it's been a long day, but I will,
No, I think I understand your position. Yeah.
Thank you, Your Honors.
I'll just say one thing. Plaintiff did not do nothing. I mean, it took a while before they got all the proofs in because there were multiple IMEs and Mr. Bazzi was deposed before he died. But then all of that's together and plaintiff keeps trying. I went through every letter that was sent. So it's not like we were sitting on our hands.
You know, maybe I'm misunderstanding Mr. Jaskolski, but do we have an enforceable arbitration agreement here?
Well, we have an agreement that was signed by Mr. Burns here and by the then attorney for Citizens. It's sort of peculiar because it's under a fax cover sheet, but nobody has disputed that they'd agreed to arbitrate.
Okay.
Thank you.
Case is submitted. Thank you very much.
Yeah.
I hate to do this, but we're going to have to take a 5-minute break. That was an unavoidable break. Yeah, she's remote. Okay, calling case number 15 on our docket for today. Case number 375-353, N. Ray Anderson Atwell Miners. The appellant, ready?
I'm the appellant. Yes, I'm ready.
I have at it. Is she
Okay,
there?
there she is. Okay.
Good morning or afternoon, excuse me.
Good afternoon, Your Honors. Eric Scott. I'm appearing on behalf of your appellant, Christy Anderson. I know the court's read my brief. I think I've outlined a number of the issues pretty well in there, so I stand ready to answer questions. I just have a few minor points I wanted to supplement with. One of the most important aspects of this case really is the timeline of how things transpired, because it affects every aspect of this case. And it's really a matter, I've laid it out in 3 separate arguments, but it's really a matter of the entire circumstances that leads to the problem in this case. Sounds like you have a question.
I do, but if you want me to wait, I can.
I can answer your question first if you want.
So my first question just really goes to the due process argument.
Yes.
I want to know, how much time did you have to discuss the new petition?
The case, you mean the attorney counsel?
that's
Yeah, I was not trial counsel.
okay.
So
So
Ms.
how long-
Weisenbach had approximately, sounds to me that she got the petition maybe an hour before the hearing and never really had much of an opportunity to speak to her client about the petition itself. From what I can gather, it was about a half hour at most that she had a chance to talk to her. From what the record reflects, it sounds to me like the petition was literally handed to her client as her client was walking in the courtroom. So that's one of the aspects of the timeline that's problematic. But the bigger aspect is the caseworker knew about the drug screen on April 8th. If you look at the timestamp on the petition itself, and I'm talking about the April 14th, the petition that was filed on April 11th, that caseworker knew about the methamphetamines test on April 8th. The petition itself bears the signature of the prosecutor on April 9th. It doesn't bear the caseworker's signature until April 11th, 3 full days after she had the information. And then at that point, if there was in fact an emergency, the court should have held a hearing either on April 11th, which would have been a Friday afternoon, or Saturday morning. Under the court rules, 24 hours if there's a removal request. But the problem here is the court didn't entertain the removal request until April 14th, 6 full days after the caseworker knew about the problem. And here's one of the biggest.
Court offer an adjournment?
I'm sorry?
Didn't the court offer an adjournment?
The court offered what I would call coercive adjournment.
Let's say you will temporarily place the children with somebody and then we get back to it. I mean, they offered the adjournment and a temporary placement.
That is correct. I don't dispute that, Your Honor. The problem is whether or not there was actually an emergency that warranted that removal on the 14th. And this is where the timeline becomes really important. Because if there was an emergency, the emergency was on April 8th.
Counsel, can you point me in terms of the need for an emergency or imminency? I guess point me to the legal requirement there. I feel like the statute says a substantial risk of harm, correct?
It does.
So then, how has that been construed to require emergency? Is there something else you're relying on, or where is this?
Your Honor,
bring this down for me, please.
If I may, MCL 722.637 applies here. And what that first section of that statute, 722.637 subparagraph 1, says that DHS must file petition within 24 hours after determining that a parent has exposed a child to methamphetamines. They knew on April 8th, at least they believed on April 8th, that my client had exposed this child to methamphetamines on April 8th. When did they file the petition? 3 days later, 72 hours after they knew about it.
Does that, I mean, I guess, so let's, if that's the statutory requirement, it doesn't get complied with. Does that mean that now the petition can't be filed?
It doesn't mean it can't be filed. What it means, though, is DHS either didn't believe it was an emergency, or didn't believe that my client had exposed the child to methamphetamine, because the second half of that statute gives the exceptions that says when DHS does not have to file. And all three must apply.
722.637 talks about initiating child protective proceeding. The state must file a petition asserting facts that constitute abuse or neglect of the child.
Yes.
Does there have to be an emergency?
What it says, it has to be filed within 24 hours. It doesn't use the words emergency, but 24 hours would indicate that there must be some kind of emergent basis, some required necessity to get this case in front of the court quickly. And if the second half of that statute gives exceptions when DHS doesn't have to do that. And the problem is this case doesn't fit into any of those exceptions. DHS, when they wrote this petition, they believed, and I'm not conceding that there was actual drugs use or not. I'm just saying they believed at that point in time that my client had exposed the child to methamphetamines. That triggered a 24-hour clock.
Did you cite 722 in your brief?
Honestly, Your Honor, I didn't, and neither did
Did
Miss.
not, because I'm looking at it.
Yes, and as I was preparing, I looked at that statute in more detail, Your Honor, but I also know that Ms. Moore didn't cite it either. But
That's an important statute for your argument. And
it is, Your Honor.
it's not in front of the court, but at least I'm looking for it now.
Yeah.
But you're asserting something that's really a key issue here.
Yes.
And you decided not to put it in a brief, which is very surprising.
Yes. And Your Honor, but I do lay out the importance of the timeline in the brief, because the timeline really is the problem here. If there was an emergency, it should have been addressed well before April 14th.
In your view, it should have
Yes,
been addressed.
it should have been. I mean, because if we're talking about taking children away.
And they were talking about taking children away temporarily to allow for an adjournment for your client to consult with their attorney and whatnot. And your client said no.
Well, Your Honor, that is mostly true, but the problem is the court made it an either or proposition. Either I remove the children today temporarily, and then we revisit the issue tomorrow, or it really was, I kind of lost my point here, Your Honor, I'll be honest, but the court made it contingent. I will grant the adjournment if you agree to let me take the children away temporarily. That's the problem. That really is the crux of the issue.
Why is that a problem?
Because it's coercive.
Why?
Well, it's coercive because it tells the parent, you're either going to get your children removed today, and then we're going to revisit the issue temporarily, but with no guarantee that the next day you're even going to get the opportunity to revisit the issue. And this is where I get to the end of the brief, because the actions of the referee at the end of the hearing is part of the problem, because the referee allowed DHS to put on 2 witnesses. It took a 10-minute break. Ms. Weisenbach, the trial counsel, got to question those witnesses. But when the court came back on the record, the court said, I'm not going to let you argue anything. I'm not going to let you present any proofs. Ms. Weisenbach never even got the opportunity to present her own case. MCLR 3.965 very clearly says that a parent in this situation gets to at least confront the witnesses and present their own proofs and their own arguments. And that referee came out and summarily said, no, we're done. I've made my decision. And that's where the coercion really is solidified. It's not just, she said, I will take the kids away temporarily today, and revisit this tomorrow. It's that she took the kids away temporarily today and said, DHS, you can put on your own proofs, but Ms. Weisenbach, you can't. There's the problem. That's the due process problem in the whole case.
965B11 allows for adjournment and temporary placement of the children, correct?
It does.
Right.
But it also says that the court must give the mother's attorney, it must give the parent an opportunity, a meaningful opportunity to participate.
Right now, I mean, I guess if we assume, at the time the adjournment was offered, I don't know if there's anything in the record to support the notion that the court was planning not to give a full opportunity. Now, I understand we get to the hearing. I know that your position is that it didn't happen and the court was violated because she was not given the opportunity to make her case evidentiarily or through argument. Is there anything in the record to help us know what that case would have looked like?
We don't even get there because she didn't even get the opportunity.
I know we didn't get there, but but a lot of times what I see here is maybe we have an error, maybe we have a violation. But then oftentimes the next inquiry is, what's the prejudice? And we need something to kind of help us understand that.
You know, I've done this for a number of years on both sides of the table. I've been a prosecutor doing this. I've been a CPS caseworker. So I've seen a lot of these cases, Your Honor. And you're right. In most cases, defense counsel wouldn't have much to bring. I agree with that point. But we don't know that.
Right, well, here defense counsel had the opportunity to cross-examine, correct?
Yes.
All right, and then there was some discussion held off the record with the trial court, correct?
No, my understanding from reading the record is that the trial court, the referee went off the bench, came back 10 minutes later, went back on the record and said, "We're done. I've made my decision." And
I
that's,
understand that there was some discussion off the record and there was no closing. And it looks to me that after the discussion off the record, people were satisfied and then the trial court went ahead.
well, Your Honor, but that still doesn't eliminate the issue because this was an issue where she should have been given the opportunity to at least
Just
say
to
on the
close it,
record.
So your issue is with, she had no closing argument.
She had no closing argument. She wasn't even given an opportunity to present her own proofs. It's not just that she didn't have a closing argument. It's that the referee simply said, "I've made my decision" at the end of DHS's proofs.
But in the time since, there have not been any haven't been any offers of proof or affidavits about, hey, here's what we would have put on. Here's what the testimony would have, here's how this would have actually.
To the best of my knowledge, no, Your Honor. And I believe this case may have been tried at the end of October. It may have gone to trial, but I haven't followed it from that point, to be real honest. So, but my point, I don't typically do that as far as an appellate counsel is understood. But it's my understanding it did go to trial. I don't know what issues were raised in trial.
But we don't know what witnesses or other evidence would have been presented on the 14th, correct?
That is correct. And that's what the issue is we don't know if she even had a defense because she never got the chance to present a defense. And she may have, she may not have, but she should have at least been able to articulate on the record, "No, Your Honor, I rest my case. I want to make my argument."
He doesn't articulate anything now.
Yeah.
Okay.
Nothing further from me.
Your Honor, do I have time for rebuttal?
Yeah, you do.
Thank you.
Of course you do. Plenty of time.
Thank you.
Okay, Ms. Moore.
Thank you, Your Honors. Good afternoon. May it please the court. My name is Phoebe Moore. I'm here on behalf of the Huron County DHHS. I was not trial counsel. I just want to only add to the record. I know you've had a huge day. Judge, the timeline just relative to your question regarding the timing is on page 10 of my brief. The preliminary hearing commenced at 2:26 p.m. and mother's counsel revealed that she met with the mother, her client, at 1:20 p.m. So that would be an hour and 6 minutes, just to specifically answer your question to brother counsel when he started his argument. I want to just add briefly today that we go through these briefs and we do write these briefs. I've been doing this for years and so has Mr. Scott. Quite frankly, we've both been on both sides of the V here in these cases. We state these standards of review, and of course it's clear error in child protection proceedings. But relative to preliminary hearings, the court in Williams laid out a new standard, and that's on page 18 in my brief, which states that any error in the trial court's removal order is not grounds for reversal unless it would be inconsistent with substantial justice to permit it to stand. So any error in the trial court's removal order is not grounds for reversal unless we've got this substantial justice. I think that's a higher standard, if you will, for this particular hearing before you, Your Honors, because of the fact that really we only have to find probable cause and we have to comply with these court rules. At the end of the day, this was a valid preliminary hearing. And I think the timing, I do agree with counsel that the timing is entirely important because we had two, not just one preliminary hearing, but two. This referee heard all of the facts from the first preliminary hearing. Mother had her counsel present. All parties knew what issues were at bar, specifically the drug use, the inability to supervise these children and have others in the home and sharing drugs or the vape pen and other things with the minor children. And the referee gave her a pass and said, "I'm going to let the children stay with you. But let's be mindful." Then mother agrees to the drug testing. So this whole argument of the, Fifth Amendment and due process. She agreed to the drug testing. And who else knew about the drug testing at the final preliminary hearing on April 14th? The mother. Mother knew she was tested twice. So to say that she had no knowledge of what was going on is really unfair based upon the record. And Judge Warden, I also do agree with you certainly that on that record, if you look at page 39 of the April 14th transcript, the referee says, after they go off the record, she says, I'm going to go off the record for a second. 10 minutes later.
What exhibit? Is that one of your exhibits?
It is. Oh gosh. I'm sorry, Your Honor. I don't know which one.
What pages is it? Page 30?
I'm on page 38 and 39 of the April 14,
Yeah, I got page
2025
39 in
transcript.
front of me that you submitted.
Yeah,
Somebody
okay.
that you did exhibit E. Okay.
Yeah, okay, good. And she says, I'm going to go off the record for a second. And she comes back on. We're back on the record in case number, the number. We went off the record just to check a few things. With regards to the hearing, the court is just going to make a decision right now instead of any argument or anything because frankly, I'm ready. At that point in time, no attorney objects and says, wait, I want to make an argument. Wait, I want to call a witness. And if you scroll down, so we don't know, of course, none of us know on this record what happened in that 10 minutes. I can assure you, and so can Mr. Scott, that Ms. Weisenbaugh has been doing this for 30 years, just like Mr. Scott and I, and she knows all of the attorneys quite well, along with the referee from Huron County. So, these hearings and negotiations tend to be amicable. But if you scroll down, after she gives her really long-winded ruling about removal and goes through all of the factors of 3.965C, it comes down to Ms. Weisenbaugh. And she says on page 43, with regards to parenting time, I know that they're going to set the minimum standard out, and then there's this discussion about parenting time. Without doubt, Your Honors, this counsel could have said at that time, I'm sorry, I didn't get oral argument. I'd like to preserve my objection for the record. I'd like to call a witness. I'd like to adjourn for good cause because I'd like to subpoena somebody. Nothing.
Well,
So
she
if you-
did question Mr. Hunter. Any conditions or orders you'd like to see added that I missed? No, Your Honor. All right, Ms. Weisenbach? Okay, with regards to parenting time, all right, she did have. Okay.
Right, exactly, Your Honor.
Yeah.
And they do look after the issue of parenting time, and then she then stipulates to the PBT if you go down further, which goes into, the second argument I think made by the attorney here. But so there's just simply no violation on this record. And if you look closely at MCR 3.965, again, there's simply no requirement that someone's given notice or so much time before the hearing. This isn't 2.119 where it's 7 days, but by hand, 9 days by mail. This is a child protection proceeding. And in 3.965A1, it says the preliminary hearing must commence no later than 24 hours after the child has been taken into custody. We haven't even gotten there yet, and we're giving her a preliminary hearing. But there's simply no other guidance, no other court rule, no other statute that we can point to. But I have to, and I wanted to say a whole lot more, and I know that you've had a long day, but I have to jump to the 722.637. Judge Warden, I don't know if you pulled it up, and this is the one time I'm on Zoom, which is actually quite nice for purposes of pulling up statutes. And thank you, Your Honors, for allowing me to attend by Zoom. I really do like to attend, but I'm up north now. But if I read from 722.637 subsection 1, here's what it says. Except as provided in subsection 2, within 24 hours after the department determines the child was severely physically injured, as defined in section 8, sexually abused, or allowed to be exposed to or have contact with methamphetamine production, the department shall submit a petition for authorization. Let me read it again. Or allowed to be exposed to or have contact with methamphetamine production. How is a positive test for methamphetamine somehow exposing a child to meth production? I would ask the court to respectfully reject that argument brought by counsel today. It's not only late, it's simply inapplicable. She tested positive for methamphetamines. And mind you, if you look at the test results, 4 times the legal limit, twice since the initial hearing in March, and claims she was somehow, her rights were violated.
Well, counsel, can I ask you a question just in terms
Yes.
of the procedure here?
Yeah.
the petition was filed on the 11th.
Yes, and that was a Friday, just so I understand.
I understand. And obviously we know that, it's very important matters here for everybody involved. Why, is there any dispute that the petition was not provided to the respondent until the 14th?
No, not based upon what I've read on the record.
So why is that?
I don't know, Your Honor. I'm sorry.
Okay. And I think we've talked about the record in terms of what happened at the hearing. It seems like, we know the court, there's no objection, but also no clear statement on the record about why the court decided that it was ready to rule and proceeded to do so kind of at the juncture in the hearing that we did. We just don't know. And we don't.
Yeah, we just don't have the knowledge. Can I speculate? Can I say it was Friday afternoon, a nice day in April, and somebody didn't want to work or somebody didn't want to have a hearing and go serve the petition? I could speculate to all those things, but I can't. But at the same time, I think it's important that we all understand, simply because a department representative, or maybe it was a court representative that said, hey, we're not having this hearing, it's set for Monday, they can come in on Monday. We don't know what happened, but does that make it unsafe, or does that mean we shouldn't protect children simply because we have these proofs 3 days later? Absolutely not. It doesn't make sense. It's not a valid deduction to say, well, simply because you didn't bring it straight away doesn't mean there's not harm to these kids. I think it could have been done better, but it doesn't. Yeah. Okay.
Yeah, I understand. And obviously we're in a tough spot because we have very important interests, but then also we have, a claim of a due process violation, which in itself also is important too.
I certainly respect that and couldn't agree more. But in any event, I don't think that there was good cause demonstrated by the mother for an adjournment. These cases can be adjourned for good cause. That is articulated in 3.965B11. There was no good cause. In other words, the counsel just said, I didn't have time. And then brother counsel goes into this, oh, it's a new petition. They should have gotten notice. To read 3 paragraphs? That's the only thing that was different in the amended petition, to read 3 paragraphs of that included 2 drug tests that she took herself, that she knew the results of. So without a doubt, this referee knew that she was obligated to articulate those contrary to the welfare findings and reasonable efforts findings. And I will say, Your Honors, that a lot of appellants counsels in these cases cite all of these, this case law that says, oh, judges have to be specific. They have to list the contrary to the welfare findings. They have to list the reasonable efforts findings explicitly. Those cases, just so you understand, are all dated prior generally to 2022. And in 2022 and in 2024, you'll see the new SCAO forms for the order after preliminary hearing and the order to take the child. And you see that the SCAO now leaves blanks under, for example, contrary to the welfare findings, and they'll say, see attached, or, fill this in. And all judges fill those in. This referee went beyond that. She gave specific findings on the record and in her order to take that said, listen, I made these findings in March that we've got some serious concerns about drug use. And then mom came back and tested positive, substantially positive. And we've got this supervision problem in the home where she just tries to make it look good and have somebody over. An adult was supposed to be in the home and clearly wasn't. So we have adequate findings that were specified. And so there's simply just no firm conviction that any mistake was made. And we respectfully ask this court to affirm the lower court. Thank you.
Okay. Judge Garrett.
Nothing further.
I thank you very much.
Your Honor, do I get to end?
We'll give you some time. Of course you have time.
Just a couple points, Your Honor. Ms. Moore raised the question about substantial justice, and that's really what this is about. Substantial justice didn't occur here. DHS had from the 8th to the 14th to prepare. Prosecutor had from the 9th through the 14th to prepare. The court had from the 11th through the 14th to prepare. Following even conceding Ms. Moore's argument that Ms. Weisbach had an hour to prepare. She didn't have 3 days. Her client didn't have 3 days. The court and everybody else got at least 3 full days to prepare. And Ms. Weisbach was walked in an hour before the hearing and said, you got to do a hearing in an hour. The other point I would make is if there wasn't, Ms. Moore is correct. There could have been another hearing. The question is, was there an emergency that warranted doing that removal on the 14th at that time? There's no reason the court couldn't have just simply adjourned it and taken the issue up as far as removal the very next day. Good cause actually was provided. I didn't get notice. That's what Ms. Weisenbach said. My client didn't get notice. There was no reason after the court and DHS had left that child, those children in that mother's care from April 8th to April 14th, that the court couldn't have waited one more day. There's no reason at all the court couldn't have waited one more day and done a removal hearing the following day, allowing counsel to prepare. And that's the important part here. That's what I'm pointing out. There was no emergency that required the court to go forward on April 14th. DHS conceded that by waiting so long. The prosecutor conceded that by waiting so long. The court conceded that by waiting so long.
Thank you.
Thank you very much. Good
Thank
luck
you,
up in
Aaron.
Huron County. Safe travels home.
Thank you.
All right.
Thank you.
Merry Christmas to y'all.
Merry Christmas to you as
Same to you.
well. Thank you.
That case is submitted. Calling number 16 on our docket. Case number 376009, Ann Ray Carrico Smith Minors. Having no parties endorsed, that case is submitted on the briefs. Calling case number 17 on our docket, case number 370157, People versus Vertice Stephen Woods. Having no parties endorsed, that case is also submitted on the briefs. That concludes our oral arguments for today. We'll see everybody here tomorrow. That's us.